Made, please, Your Lordship. Well, in respect of item number 2, we have filed to IAML. May I be permitted to bring those to IAML? Okay, deeply. Deeply. Item number 1.
May I, Lordship? Oh, I beg to mention item number 8 on behalf of Mr. K. Tama, counsel for respondent number 2. He is out of station. Matter may be listed after 3 weeks.
Item 8. Just a moment. Wait for 2 minutes. Nobody's here.
Your Lordship, I beg to mention item number 7.
Kindly button up your coat. Kindly button up your coat before addressing. Just wait for 2 minutes. Let the secretary come. You sent. In respect to item number 8, on the ground that the learned counsel for the petitioner is on leave, declare for adjournment till wait. Period is allowed. List after ensuing vacation, due vacation. Yes.
Item number 3 and 4.
Item number 3. Yes.
Like mentioned on behalf of P. Tagum, standing counsel for.
Just wait. Let the matter reach. We need the prayer when the matter reaches. Yes.
Your Lordship, I beg to mention item number 7.
Seven.
It is a LSC matter.
Hmm.
Learned counsel Miss N. Dangan is out of station. Kindly matter may fix after 3 weeks.
Lordship, 6 and 7 is connected. Even in the item number 6, the learned counsel for the appellant, she is also, Your Lordship, out of station. Since I've been informed. So both the matter may be adjourned, may be listed after 3 weeks.
Okay. Both sides are represented. On the ground that the learned legal aid counsel is not available, the prayer for adjournment has been made. Prayer is allowed. List after ensuing due vacation.
3 weeks. Yeah.
Oblige.
Due vacation, I am sorry.
Okay, I'll deeply obliged.
Lordship, I beg to mention item number 8 on behalf of Mr. K. Tama, counsel for respondent number 2.
Somebody made a mention.
Already.
Somebody made a mention.
Obliged.
Item 8, Your Lordship.
Item number 1.
May I please, Your Lordship, Your Lordship? May I please, Your Lordship? Lordship, I am appearing for 1, 2, 3, 4,
Please
and
button
8
up your
and
coat
9.
first. Button up your coat. This is definitely not a fashion parade. Yes.
Your Lordship may kindly allow us 3 weeks time for filing our affidavit.
How much cost will the state pay?
Yes, Your Lordship.
How much cost for adjournment? The petitioners filed this PIL because the road condition is bad.
Your Lordship, we are yet to receive our instruction.
You will never receive it. For bad road, what can you do? Even in the, you see, even in front of the High Court, the road is so bad. Have you noticed? Then
You get an adjournment only on cost.
Your Lordship, kindly allow us, for the last time, Your Lordship.
But you see, the road condition is bad. At least you'll have to have some instructions and tell us. It's a PIR. You can go out, have a word with the authorities and tell us. Give us a date when the affidavit will be filed. After some time, we'll take it up.
But, my instruction is, this road does not fall under RWDs, and they have not executed the work.
Okay, so this is not a state road.
No, RWD department, RWD is one of the party. Responded
Somebody must tell us.
6 and 7.
Somebody must tell us. The state can't say this is not our road. Whoever department does the road topping. Somebody will have to tell us. This is not a good instruction. You find out and tell us, otherwise we'll impose cost. We'll take it up after some time.
Obliged.
Obliged, Your Lordship.
Item number 2 after the IS.
Okay.
Yes. Item number 5.
This matter pertains to framing of rules under the freedom of religion act.
Just a moment, what happened to 4?
Oh, it's also there.
Item number 3.
Just a moment, AG. Mark.
Item number 3.
Hello, there is a delay about
Mr.
24.
Professor, you'll have to button up your coat.
Yes. "24 days delay. And my lord, I have been
Item
told that
number, your first item, item number
3 and 4.
3 is liable to be dismissed.
Pardon, my lord,
Item number 3 is liable to be dismissed.
why?
Look at your cost title.
Procedural of
Yes.
IA.
Who is petitioner applicant number 1?
Association,
Correct, please read it. I'm
all Arunachal Pradesh Elementary Teacher Association.
represented by its president, Sri Pil Thakur.
Field Hub.
Correct. Who is applicant number 2? Pil Thakur, vice president.
Yes.
So man is also a president, he is also a vice president, and he constitutes 2 applicants. And they have filed this.
My lord, at present, he is the president. And earlier, at the time when the petition was filed, he was
We don't
president.
know. A man cannot hold 2 posts. He cannot be in an association, he cannot be president and vice president.
No, I will make a correction. No, only, my lord, instruction that present he is.
But look at our difficulty.
My lord,
Not only we have to read the brief, we also have to now check the name of the parties.
my lord, sorry. Sorry. I will make a correction, my lord.
Okay.
Keep it, sir.
It is seen that the applicant number 1 and applicant number 2 are the same person having, as applicant number 1, he is representing himself to be the president of an association. And as applicant number 2, he is projecting himself to be the vice president. Next paragraph. On a prayer made by Mr. A.K. Prakash on counsel for the petition applicant, the matter stands adjourned today to enable him to amend the cost title. Next, for the amendment of the cost title shall be done by submitting a type copy of the cost title to the to whom it should be given. Cost title will be amended before whom?
No, they will have to file the amendment.
Amendment of discussed in section. Before the AOJ civil law section. And thereafter the matter will be listed again.
Three.
4, my lord, 3 and 4 out of same common judgment.
But again, in item number 4, issue of maintainability will come. In item number 4,
Yes.
you are saying that you are all members of the applicant in item number 3.
Oh,
You can't file 2 appeal.
no, initially, my lord, they filed a separate writ petition, present petition. Then, my lord, suggestion was come
Please.
from court.
Please tell me,
Not-
you are member of the, your admitted cases that you are member of the
My lord.
petition, item number 3.
My lord, court says, my lord, whatever the other petitioners. Then, my lord,
We don't know.
Court says-
In the judgment, you 3 are not the parties. So you'll have to file a leave to appeal before you present an appeal.
no, we are the parties in, my lord, we are the parties in the original writ petition.
Where is it? In the judgment, your name does not show.
161,
In the judgment, your names do not show.
because there is a reference of two writ petition.
We don't know which you see. Are you expecting us to read everything and come? We are just looking at the judgment.
Yes.
You have annexed the judgment at page 586.
There is a reference of both the judges.
Show us. Those will be wrong.
Yes,
We make a-
at page,
we make
my
a
lord.
mistake.
Yes. At page, my lord, 16.
6.
And of writ appeal. And what you will find at 11 page 618, 151. WBCO, 151 of 2018.
I don't know the last page in this
618.
in this item number 4, the last page is 607 in our brief.
My lord, at page, my lord,
Yes,
588.
580,
88. 88.
580, 18, 88, okay, 588.
There's a common judgment estimate of both the writ petitions.
Just a moment. Oh, yes, you are there. I made a mistake. Okay, who is opposing this?
State government,
IA?
you know, on the very first day, they took time to file.
Are you opposing this seriously?
4, 5, 6.
Pardon me? Well, this item number 4, anybody is opposing it? The prayer for 24 days delay?
No.
No.
No, madam.
Okay. Well, Mr. A.K. Purkar, sir, and counsel for the applicants. Also heard. Mr. N. Ratan, Learned Additional Advocate General. You will be appearing for all.
For 1, 2, and 3.
1, 2, and 3.
Yes.
And Mr.
Are going for 4, 5, and 6.
Standing counsel for respondent numbers 4, 5, and 6. Next. By this interlocutory application, the applicants are praying for controlling the delay of 24 days beyond the period of limitation in filing the connected appeal. It is projected that some time was consumed in obtaining the opinion of the learned counsel. Thereafter, to take a decision to have this intra-court appeal. Next one. Although the learned additional advocate general as well as the learned counsel for the respondent numbers 4, 5, and 6 oppose this application, considering the grounds assigned, the delay of 24 days beyond the period of limitation in filing the connected application stands condoned. Next one. This application stands disposed of. And in the appeal, we issue a notice then?
Yes.
Mr. A.K. Purkar, so this in main appeal. Learned counsel for the appellant. Mr. Ratan for the same response, same earlier. Next one. By filing this intra-court appeal. Just a moment. What is the challenge here, Mr. Purkar?
My lord. Challenge is, my lord, that we are otherwise entitled to, my lord, arrears salary on the basis of 5th and 6th episode for a particular period. Ultimately, court has come to the conclusion that it is a policy decision of the government. Therefore, petitioners are not entitled. Of course, my lord, there are other related questions. Basically, it is a policy decision, therefore, we are not entitled.
How do you say that this benefit of the 5th and 6th pay commission is an additional benefit to you?
Well, we are saying that, my lord, since it was adopted by the government, therefore, whatever area is accrued under these two policies, we are otherwise entitled. And there was some decision taken by the government, my lord, that each of the teachers are entitled to the action of certain amount. That was not considered by the court, saying that initially they took this stand. There is a, my lord, financial crisis, financial constraint, therefore we are not in a position. Subsequently, they took a, my lord, they changed the stand. Ultimately, they
But
came
you
up
see,
with,
paragraph 42, in paragraph 42 of the interim judgment,
my lord,
the court has arrived at a definite finding that the officers had committed fraud.
my lord.
It was falsely admitted by misrepresentation of factual aspects of the case without knowledge and approval of the competent authority of the education department. And therefore, the admission to grant you benefit
That was the
stated
allegation,
to
and
be,
now, my lord,
is stated to be an act of serious misconduct.
my lord, they say that, my lord, affidavit was filed by, my lord, in a culpable manner, admitting the claim of the petitioner. Ultimately, my lord, they filed an affidavit saying that these two officers are, my lord, involved. Now, both the persons are reinstated.
Reinstatement is something else, but the
And,
misconduct
my
is
lord,
there.
criminal proceeding was initiated,
But
but
the
ultimately,
misconduct is there. They may have-
misconduct maybe may not in respect of those two persons. And, my
But
lord,
if-
what is the allegation that
but
we
if
are
that-
involved?
But if that admission goes,
My lord,
the judgment of this non-single that warrants no interference.
Admission, ultimately, they took a stand that those two persons policeably filed affidavit. And that earlier affidavit was withdrawn. Now they come with a fresh affidavit saying that it is a policy decision of the government. And therefore, we are not liable.
Correct. What is wrong in that?
No, Supreme Court says, financial
But
crisis
the director,
or policy decision cannot be the basis.
Cannot
Because
be?
right to salary is a part of fundamental right of Article 14 as well as Article 21.
No, recommendation of the fifth and sixth pay commission must be accepted by the state government unless they do it.
My lord,
There's
there is
automatic benefit.
no any record, no record could have been placed on record, or no, my lord, motivation was even, my lord, produced before the court, said government took a decision not to pay the area salary.
Mr. Prakash,
Initially, they said, my lord, we are not in a position
can
to pay.
a negative be proved? Can a negative be proved?
No, negative
If the
cannot
government
be
has-
proved.
If the government has not taken a decision, it has not taken a decision.
Government is supposed to, my lord, place on record that this is the decision we have taken.
No, not required, Mr. Prakash, you are.
My lord,
it
we
cannot
relied
be
on
accepted.
Lord, we will examine this question.
We'll discuss it right now. We are examining it.
No. Court says that we have, initially they have the problem, they are not in a position to pay the area salary because of financial crisis. Then they took a decision, there was a negotiation between the association and the government. One part was relinquished. Then
See.
subsequently they came,
The state, it is your burden to show us that the state government took
Madam,
a decision
my lord, once
to
the,
implement fifth and sixth pay commission
My
in
lord.
respect to the petitioners.
my lord,
That is the positive thing which you have to show.
my lord, as part
There
the,
cannot be a presumption that.
as
the
per the
legislature has
Arunachal
accepted-
Pradesh adaptation rule, once the sixth CPC and fifth CPC was adopted by the government, there is no scope to, my lord, decide that.
Shows the document.
My lord, we have produced on record, that was not
Show
considered.
us. We are ready to read it.
Now,
Show us.
today, my lord, I am not ready in the sense, because initially they thought that, my lord, I was made an impression they are going to file an objection. Therefore, my lord, I am on
That
condemnation.
can't be. You have traveled from Guwahati to here,
Well,
just
that's
not to
right.
be prepared.
No, I thought, my lord, today court is
No,
going to consider my prayer for continuation today.
We have done it and the matter is listed today. In
And today is
internal
not
bench.
fixed for, today is not fixed for admission.
It is not.
Today is not
Are
fixed
you-
for admission, therefore I.
Are you right? Okay. On a query of the court as to whether there is any positive document to show that the state government has adopted the pay commission recommendation of the fifth pay commission and sixth pay commission. Mr. A.K. Prakash, learned counsel for the appellant submits that today is not the date fixed for admission hearing and therefore he is not prepared. Full stop. Mr. N. Ratan, learned additional advocate general, and Mr. I forgot your name. R. Koyu, learned counsel for the education department are present. Matter stands adjourned today. List after ensuing due vacation on a date to be fixed by the registry in the admission column.
this matter pertains to framing of rules under the Freedom of Religion Act. In fact, it was disposed of by an order dated 30th of September. If you will kindly turn to page 9 of the IM.
Yes.
The Lord will kindly turns to page 10. This is the order by which it was disposed of. The fourth paragraph, your Lordship will kindly see. So and so, Advocate General submits that the finalization of the rules would take at least another 6 months' time. And accordingly, last paragraph. However, we expect the concerned authorities to be mindful of their obligations and draft rules should be finalized within a period of 6 months. There was an expectation expressed. This issue has become slightly sensitive. And the government has ultimately decided to constitute a committee and a consultative process with all stakeholders. So we will require some further reasonable time. So that is why this IA has been filed. Although there was no positive direction as such, mandating us to do it within 6 months, but we thought that showing due respect to this honorable court, it would be proper if your lordships pass an orders, allowing us a reasonable further time.
Yes, Mr. Pame.
I pray some time to filing the written objection.
Objection. Okay. You should notice, we just say, had Mr. I. Chaudhary, Learned Advocate General for the state, assisted by Mr. S. Tapil, Learned Senior Committee Advocate, for the for the applicant. As well as Mr. L. Permit, Learned Counsel for the respondent. Next one. This court, by an order dated 30/9/2024, disposed of PIL 16 of 2022 with an observation that the draft rules in connection with the Arunachal Pradesh Freedom of Religion Act, 1978, would be finalized within a period of 6 months from the date of the order. Next paragraph. The Learned Advocate General has submitted that although no specific mandatory direction was issued to finalize the draft rules within the permitted time, the court only expressed that the state would be mindful of their obligations to finalize the draft rules. So accordingly, it is something that for the purpose of considering the matter in the entirety, the state government intends to refer this issue to a select committee.
My lord, just a committee.
To a committee to examine all the aspects. And accordingly, it is submitted that there is likelihood of six more months in finalizing the rules. Next paragraph. Issue notice in this interlocutory application, which is made return within 4 weeks. You have received a copy.
El Permimel.
You have received a copy.
My lord.
Mr. L. Permit under counsel, the respondent raised for his granted time to file his objection, if any, this after 4 weeks on a date to be fixed by the registry.
May I pray for a date after 4 weeks? Any? Maybe around 5th of May.
Okay, 5th May.
Did you?
Obviously.
This matter can be disposed of, my lord. Although the brief is voluminous, but the issue involved, my lord, is very small, my lord. What happened? The private respondents in the writ appeal, they were the writ petitioners. They were promoted as from JE junior engineer to assistant engineer in the year 2006 on officiating basis, ad hoc basis, my lord. Their regularization was never done, my lord, by way of a DPC. Only in the year 2020, a DPC was conducted, on which date they were regularized with effect from the date of DPC. Before the learned single judge, my lord, the retrospective regularization was claimed by the private respondents here from the date of the ad hoc promotion, my lord. But the issue that whether they were entitled from that date was not there, ma'am. However, by the order of this honorable court.
Mr. Ratan,
Yes, ma'am.
there's an earlier order of this court
Yes, we have complied with.
asking you to file
Yes,
a copy of the gradation list
Yes,
of
ma'am.
the cadre of assistant engineer.
Yes, ma'am.
There's another order by which we directed you to file an affidavit.
Yes,
Has that affidavit been filed?
yes, my lord. We have filed, we have filed the affidavit, additional affidavit filed on 16/9/2024.
16/9.
Yes, ma'am.
What is the stand taken there?
There, the gradation list and the men in position year wise has been given, my lord. In the affidavit as well as in the annexure.
Just
Well-
a moment.
Page 149, my lord, if my lord has been that annexure.
Okay.
My lord, this is from 2005 onwards, my lord. My lord will see initially what was the position. The writ appellants as well as the private respondents also have agreed to this position now.
DPC has been held.
No, my lord. We are going to hold DPC, but because of the pendency of this writ appeal,
No, this holding of the DPC.
there
statement
is an observation by this honorable court. Before holding, you have to file this affidavit, bringing on record the position of the men and this year-wise men and position, my lord. Now they have agreed. We have come up, although the private respondents, they claim to be regularized with retrospective effect from 2006. They have now agreed that they were not entitled because from 2006, but they will be entitled from 2011 onwards, ma'am. After chalking out the men and position.
Please come to page 161.
Yes, ma'am. This is also an agreement between.
No, that's okay, but the no objection is to have the retrospective effect to the DPC dated 19/10/2010. So now you are saying that the petitioners, the appellants have agreed to 2011.
This, my lord, will say retrospective promotion declaration, no objection to retrospective promotion of ad hoc AEs against promotion quota after the date of DPC held on 19/10/2010, my lord. In 2010, there was a DPC wherein the private respondents, they were not considered because they were beyond the promotional quota. But since the private respondents, they were never, there was no DPC held thereafter, they were given regularization only from the date of DPC in the year 2020. They came before this honorable court saying that we were promoted on ad hoc basis in 2006. We were not considered in 2010. We have to be given retrospective promotion from 2006, from the date of ad hoc promotion. That now the position, whether they were in the promotional quota or not, we have brought into.
You see, a lot of cases are being filed by the engineers in the works department
Yes, ma'am.
because the government has taken up a policy of not having a DPC and you are giving ad hoc promotion from here and there. You are not maintaining seniority, and therefore there is heartburn in many persons in the cadre of junior engineer. People, yesterday also we found a matter. There's a likelihood of the petitioner being retired before he gets any promotion. And you are holding, you are continuously giving all ad hoc appointments as assistant engineers. We'll have to give a blanket ban.
My lord, there is already 2 orders by the chief secretary saying that to conduct regular DPC within 6 months, my lord, every year. My lord, but situations arises sometimes the departments.
Does anybody believe in the chief secretary? Any department has faith on the chief secretary?
My lord, some departments are regularly. When some
If this man was holding authority, he would have taken departmental action against those officers who are not doing it.
that would have been better, my lord. My lord, in any case, my lord, this position, men and position, they have agreed the writ appellants as well as the private respondents. Now only the permission of this honorable court, my lord, to hold DPC. Otherwise, no one is benefiting out of it.
Where is the order to stay the DPC?
Yeah, my lord, the very order by which this honorable court has directed us to file this affidavit, my lord, that is 35 to 2024. What are you practicing? एक तो ऑर्डर करना है इसने ये किया था
Lordship. Yes, Lordship. As of now, we have already come to the consensus as per NOC dated 11/7/2024. That is page number 61.
161.
131.
161.
61.
Yes.
Yes. You also? So now we permit the DVC to undertake the exercise.
Yes.
Laws. Okay.
Yes, yes.
Good. Mr.
Titaba.
Taba, and it counsel for the appellants. Also heard, Mr. Ratan, done an additional advocate general for the state. Respondent numbers
One and
1 and 2. And Mr. Iban, done counsel for the respondent numbers 3, 4, and 5. Next one. The learned additional advocate general has referred to the order dated 30/5/2024. And it's submitted that this court had allowed the state respondents to work out the details of excess promotees and public or direct recruits existing in the cadre of assistant engineers
engineers.
in the which department?
PHE.
In the
Public health.
public health engineering department. And that on conclusion of such exercise, the department was required to prepare a tentative agenda note for being placed before the DPC, where the vacancies were required to be spelled out for grant of retrospective promotion to the respondent numbers 2, 3, and 4. 4 and 5. Sorry, it is 3, 4, and 5. So accordingly, it is submitted that the said exercise is concluded and an affidavit by the respondent number 2 has been filed on 16/9/2024. Accordingly, it is submitted that there is a consensus between the amongst the parties, i.e. the appellant and the respondent numbers 3, 4, and 5. By virtue of which The respondent numbers 3, 4, and 5 have agreed to have given the no objection.
No objection is by the appellants as well as the respondents, madam.
Okay, by the appellants and the private and the respondent numbers 3, 4, and 5, which is appended as annexure 1 to the said. This is annexure 1 or annexure
I.
I? Annexure
Annexure I.
To the said affidavit. Next paragraph. On a query of the court, the learned counsel for the appellant as well as the respondent numbers 3, 4, and 5 submitted that they have instructions not to oppose the submissions made by the learned additional advocate general, subject to the adherence by the state to the dates from which retrospective effect of the motion shall be granted.
Up
Lordship,
to 2011.
there is, if there is vacancy after DPC 2010,
After the,
yes, after DPC dated 19.
That's what they are saying. Here,
Yes, yes.
they say they will adhere to this.
Yeah.
Lordship.
They will adhere to the, what I said. To the dates of retrospective promotion as given in the NOC. Correct?
yes,
Next paragraph. According to this, the consensus arrived at between the appellants and the respondent numbers 3, 4, and 5. This readable stands disposed of, granting liberty to the state to constitute a DPC to consider the retrospective promotion of the appellants
as appellants as well as
as
the
well as
respondents.
respondent numbers 3, 4, and 5. In terms of the consensus arrived at between the amongst the parties.
Well, the judgment of the learned single judge merges with this observation.
The next paragraph, resultantly, the impugn judgment an order dated 5/7/2023 passed by the learned single judge in WBC 297 of 2021 would merge with this order.
God bless.
Date down. Lordship, Lordship, in this matter, Lordship, additional advocate general Mr. Navam was appearing in this case, Lordship. I have just checked, Lordship, even the copy was, though it was filed on, Lordship, October 2024, Lordship. On, in the month of January only, Lordship, extra copies were served, as per directions of this court, Lordship. So therefore, last chance, Lordship, I'll pursue with the department, Lordship. Last chance may be given, Lordship.
How much time?
1 month, Lordship. 4 weeks time, Lordship.
You see, you'll have to just convey a decision of the government whether you want to maintain a proper road or not. Why you need so much of time?
Lordship,
You see, we are saying so because even in front of the High Court, we told you
Lordship,
Just in the front of the High Court, look at the shabby manner in which the road has been left. From UPR till here, the government could do the road topping. But when it comes to the High Court, they have left it.
Lordship, a small instruction has come, Lordship. This is but communication between the department, Lordship. It seems, Lordship, out of this communication, it seems some.
Mr. Tapin, we've got nothing. You see, I don't propose to live where this PR has been filed for the place. I don't propose to live there after my retirement.
No.
Correct. But if with the photographs which has been shown near the school, near the college, the condition of the road, which is submerged in a short rain, at least it's the duty of the government to have it repaired by whatever department they want to.
Correct.
Now we have been, the court is, because of the state inaction, we have been able to, we have been compelled to take up the issue relating to the road condition from UPR to High Court, Naharlagun to High Court. So that we have to do. Now we have to monitor the progress of the road condition in this place. How many PR should we entertain for the road conditions? And monitor it then.
So,
We should come up with a comprehensive plan.
As per this communication law, seems Lordship, some improvement have been done by the department, Lordship, in between, Lordship. Here, the authority has furnished some photographs also. Since it's not detailed, so therefore we are asking for a detailed affidavit, Lordship.
But you see, come to this photograph. If you have a copy of that, just come to this photograph. Page 43, 44, 45. You expect the children of the state to travel in this manner? Even if somebody walks, there will be dust pollution in this road. We'll first give a direction that this sand at page 43, 44, and 45 should be removed. This you are seeking 1 month time. We are giving that 1 month time.
Lordship.
But you ensure that this road should be free of this dirt. Page 43, 44, and 45.
40 also, just review this will this is between government and fiscal. This letter is this is page 14.
Here's Mr. Tapin.
Lordship.
My esteemed sister is pointing out, please come to page 39, 40, 41. Page 39 is near a school. Page 40 is near a school. Now rainy seasons are coming. Will you give holiday to the school for 3 months?
How will the children walk across this, no? Page 40, just see page.
I've
Yes.
seen, Lordship. I agree with this, Honorable Lordship, but just to obtain the present status, Lordship, I think in the meantime, some improvement might have done, Lordship.
Or we'll say that every morning in the rainy season, your officers will walk on this road in the middle of the road every day to go to office. You have to do something drastic.
Correct.
This is not a place where you can have school.
There, kind of very page 51. The portion of national highway, it means the national highway, and national highway comes under more. Means the portion of transport highway.
You file an affidavit, you file an affidavit, tell us that this is not your department, then we'll add them. You file an affidavit at least. You see, a normal general public does not know. He has filed a PIL, he has shown a photograph saying that this is a national highway. Now, who is the authority for that piece of road? Please tell us. You file an affidavit. Your name?
Marge Lombi, your lordship.
Marge Dombi.
Marge Lombi, yes, your lordship.
Mr. Marge Lombi will counsel with the petitioner. Also heard petitioners S. Also heard Mr. S. Tamil and senior government advocate appearing for respondent numbers. Will be appearing for respondent numbers
1 to 4, 8 and 9 also.
1 to 4, 8 and 9. And Mr. T. Tapak Leonard. Oh, sorry, G. Tarak Leonard. Standing counsel for the RWD, representing respondent numbers 6 and 7. You are Mr. Ibam, Leonard Counsel, appearing on behalf of Mr. R. Saikia, standing counsel for State Highway, representing respondent numbers 5. Respondent number 5. And who is water resource? Mr.
Lordship, water resource, I'll be.
Okay. Next para. The learned senior government advocate prays for some more time. Prays for 1 month's time to file affidavit in opposition to the matter. Next paragraph. The learned counsel appearing for the state highway has submitted that the road which is shown at page 41 of the 41 and 42 of the PIL. 41 to 45. Okay, 41 to 45 of the PIL is a stretch of road which is maintained by the Ministry of Road Transport and Highways. Full stop. The authorities in the state highways shall file an affidavit specifying the authority who is in charge of the construction of the said road, so that the concerned respondents can be included. Next paragraph. The next paragraph, in this PIL, some photographs of the roads which are in very bad state. Has been are available at page 35 to page 45 of the PIL. A few of the roads are very close to the educational institutions, and that the photographs of road which is shown at page 43, 44 and 45 shows a lot of dried up slush, sand, etc. Stop. The amount of slush and slush, dust and sand lying on the road would create a lot of air pollution in the area. Accordingly, while allowing time to the state respondents to file their affidavit in opposition, the Deputy Commissioner, Lower Siang District, within bracket respondent number 2, and the Executive Engineer, PWD, agency GENSI, GNC Division, within bracket respondent number 4, shall ensure that by the next date of listing, the dirt, mud and slush, which is slush and sand, which is lying on the road shown at photographs at page 43, 44 and 45 are removed so as to free the said stretch of road from any dust pollution, from any air pollution. And the said authority shall provide a photograph, copies of photographs to the learned senior government advocate for being produced before the court on the next date of listing. Next para, the affidavit in opposition by the respondents shall be filed. You need 1 month's time.
Yes.
Shall be filed within 5/5/2025. Next para, list on 7/5/2025.
Your Lordship, I would beg the court, if the court may allow me to just be heard for 15 seconds. There is one interim relief which we have been refraining from the institution of this matter to till day. We have not pressed so far, with the belief that the state may come up with a good affidavit at some point of time. So we have never pressed before this honorable court for the interim relief also.
Yes.
If the affidavit arrived, we would have done with it. But today,
What is your prayer for interim relief?
Your Lordship, in page number 22 of the original writ petition, in the page number 22,
Just tell us.
clause number 7, Your Lordship. Prayer number 7.
When they are removing dust, what is the benefit of a water spray in that road?
Your Lordship, I understand that. That interim relief which Your Lordship just dictated right now, it pertains to the zone of the National Highway. However, for this particular road which have been marked in my interim relief, it falls within the village roads inside.
Which was the photograph, which road you are referring to?
Yes, Your Lordship. Page 35, Your Lordship. 35.
35 is already submerged with water.
30, Your Lordship,
You want more spraying of water?
I have some explanation for that. Your Lordship, this road is in such a condition that on rainy day, it fills with, the potholes filled with complete water. And when on a sunny day, the same road being completely eroded, it creates such a commotion with the excessive dust pollution that, Your Lordship, it's being so difficult even to walk.
You see, we don't know. You have shown us a photograph which is submerged in water.
Yes.
If you
Your Lordship, that's why in my interim relief, I very particularly stated that taking note of the take responsibility at least to cause sprinkling when it's a high peak sunny day, Your Lordship.
You see, these things are not practicable. Number one, we don't have so much of water source in the state of Arunachal Pradesh so as to sprinkle water in the entire state, state highways and the state roads. We don't have that much of water. That's number one. Number two, without showing us the photograph of a road, we just cannot pass an order for sprinkling of water in every road. So if you want, we shouldn't say anything, we stop there, or if you want, if you are pressing for the interim relief, then we reject it.
Whatever deems fit in the wisdom of the honorable court, I may be obliged, your lordship.
You see, please go with a notion that we don't have any wisdom. That is why we need the assistance of a learned counsel.
Understood, your lordship.
If we had all the wisdom, we would not have heard you. So do you presume that we don't have a wisdom for the time being? Now the road condition you are showing us is a submerged road.
Yes.
And you are saying that please have it sprinkled with water. That is just quite not possible.
Your
Unless you
lordship,
show us the condition of the road in the dry season.
your lordship, in some paragraphs of the petitions, the petitioners have stated that these roads, there are two categories of roads concerned in this petition.
You will have to convince Shakespeare to say something else. He said that photograph speaks 1,000 words. So we follow that saying of Shakespeare.
Because your lordship,
No, we can't reward time. If you file a photograph, we do it, but it's not just quite possible. I have traveled length and breadth in the state of Arunachal Pradesh. Roads conditions are same everywhere. You can't order sprinkling of water in each and every road of the state of Arunachal Pradesh. That's quite.
because your lordship, the petitioners have been insisting me since the moment of institutional this petition way back from November. However, I personally have, that's why your lordship refrained it, understood the circumstances. But today, your lordship, given the peak of summer, it's truly, your lordship, these roads,
We don't
village
know.
sites.
I have no personal knowledge of this particular road.
Yes. We have to go by the records, no?
Fine, your
Not
lordship.
re-
Okay, if required
we
necessary, we
spoke
will
with
take the
some-
steps. If necessary steps taken, your lordship, we will bring it before the court.
My lord, we are basically aggrieved by an interim order passed by the learned single judge. If your lordships would kindly come to me, lord, page number 161, 162, my lord.
Just a moment.
The operative portion of the order is at page 160, sorry.
Mr. Chaudhary,
My lord,
please see that impugn order till
Ye-
the next, till the returnable date, the
Yes.
present tender process shall not be finalized.
without
That
leave of.
means- That means it can go ahead, only the final award shall not be made.
No, my lord, what had happened, my lord? There are suppression of material fact, number one. And number two, my lord, there is non-joinder of necessary party. If your lordship would kindly come to page number 160, 160, my lord.
Who is for the writ petitioner? You are there for the writ petitioner?
I put the Union of India, man. Petitioner is not before this one.
Why?
We have served copies, my lord.
You said-
Their names are also shown, yes. Now kindly come to page 160, my lord.
But copy is not served.
Huh?
No,
There is no caveat.
no, you see, Since I come from the trial court,
Yes.
the requirement of order 3
Ah.
is that the council will hold the brief also for the purpose of appeal. So
No, my lord,
I
if
have a
your
tendency to
lordship,
follow that because
if
you
your
see-
lordship strictly goes by CPC, then this order has to go, my lord.
No,
At
we
least
understand.
some prima facie satisfaction has to be recorded.
No, that's what we have discussed. But no, but you see the lawyer who's on record,
Yes.
he has the law provides that he would he would also be a lawyer for the appeal.
Copy has been served.
The acknowledgement is not here. I'll just show it to you. Maybe we are not disputing what you are saying. Because you see, Mr. Chaudhary,
Yes.
an ex parte order was passed leading you to file an appeal.
Yes.
Now, if we again pass something which is ex parte,
Okay.
the last page, last page is the acknowledgement, just last page.
I have seen it, my lord. That's what this is. I know.
Mobile phone was switched off. We could not work.
Lord, only thing is what had happened in this case, I'll just briefly. नाम की petition है कौन सी?
161, page number 161, names are reflected.
JP Moore,
62, I'm
C.
sorry.
Cheney.
160.
C. Cheney is here.
JP Moore, Topi Jini, P Das, A Chaudhary,
A lawyer from here.
Yes, my lord. MS Topijini, my lord, he's from this bench, my lord. She's from the lord. But this she is not, my lord, seen around.
चलो वो हाथ में नहीं है ना? Lord, if your lordship will kindly give me
Yes.
5 minutes time, my lord.
Yes.
Now, what had happened on 5/12/24, an NIT was issued for auction of, my lord, various coal blocks under the Coal India Ministry of Coal. My lord. Amongst others, my lord, for this Namchik coal block with which we are concerned, as many as 3 parties participated. The petitioner, the appellant before lordships, and one Innovative Mines and Minerals Private Limited. Now, my lord, following the technical bid evaluation, which your lordships will get at page number 159.
Yes.
Kindly see, my lord. Auction of coal mines for sale of coal list of technically qualified bidders. Please come to serial number 29 and 30, my lord.
Yes.
Namsik West. Innovative Mines, technically qualified. PRN Nuravi, that is the appellant before lordships, technically qualified. They knows it, my lord. This was on 13th of March 25. She filed the writ petition on 16. My lord, we were not made parties. Not only that, my lord, on 19/3/25, as per the tender schedule, the financial bids were open and I became H1. Now, my lord, because of the interim order, they have not communicated to me the result of the financial bid evaluation. That is why I am before lordships, my lord. My lord, having regard to the facts of the case, I'll humbly
Okay,
submit.
both of them have not been made parties.
No. That's why I said, my lord, it's a case where the principle of non-joinder of necessary parties will apply. All that I say, pray for your lordships today is, my lord, let them proceed with the tender subject to the outcome of the case. At least, my lord, there will be something to protect their right. And in the writ petition, my lord, there is no ground. Please come to 2 paragraphs of the writ petition, my lord, at page number 48 and 49. Can based on these averments an interim order be passed, my lord? Please come to page 48, para 10 and 11.
Having read it, we can't say no.
Page 48, para 10 and 11. Impugn order dated 13/3/25, rejecting the bid of the petitioner as technically non-qualified is illegal and in breach of Article 14. Why it is illegal? What was the wrong authority committed? Then 10, that by letter dated 13/3/25, respondent number 2 notified date of opening of financial bid on 93. If the petitioner is not allowed to participate in the financial bid, petitioner shall suffer irreparable loss and injury. So he knows, my lord, that on 13, technical bids were qualified and he was rejected. But he has not cared to make, my lord, the two other responsive bidders a party. And, my lord, he has absolutely no case. He has not said why the technical bid evaluation was wrong. He says it is wrong, but he hasn't said why it is wrong. Therefore, my humble submission is, my lord, let this order be modified to the extent that it will be subject to the outcome of the case. Then, my lord, the equities can be balanced. In any case, I am the highest bidder. I am a technically qualified bidder. He doesn't have a order in his favor. How can he stall the proceeding, my lord? Of interjudicial review in tender matters. In fact, Supreme Court has said, my lord, it is only an offer. The authority is not bound to accept it. When a person participates in a tender, all that he does is he gives his offer. Unless, my lord, some atrocious irregularities can be shown, there is no question of, interdicting the process. And a lot of money and effort is being put in, my lord, when as one participates in such a tender process. Number 1, non-joinder of necessary party. Number 2, suppression of material fact. Number 3, there is no reason assigned in the petition as to why the rejection of the technical bid is bad. At least, my lord, learned single judge was not informed of any reason why the rejection was bad. In such a scenario, on what basis the learned single judge, my lord, recorded the satisfaction that an interim order is called for?
As to what would be the time required to finalize the tender, or it has been done or not
Malad,
done?
as informed by the ministry, that everything has been done, Malad. Finalization, everything has been done, only just to award the work. Contract agreement has to be signed, Malad. In the meantime, this order has come, Malad. That is the instruction, Malad. The yet to enter into a contractual agreement made between the parties, Malad, by executing the formal agreement, Malad.
In fact, my lord, financial bid was opened on 19/3.
No, our difficulty you must understand, Mr. Chaudhary.
No, that's why I'm saying,
Is
my
that
lord.
any interim or no, the second part of your submission
Huh.
is again a trap.
No, my lord, all that I'm saying is it will be, let them
No.
proceed subject to the outcome of the case.
No, that's what, that is the trap. You see, once you get a work order, then tomorrow we can't say that this work order be
No, my
interfered with.
lord, no, my lord. At the instance of the writ petitioner, if this process has to be stalled, first he has to succeed in establishing that his technical bid evaluation was wrong. Then, my lord, financial bid already open. She has got lot many hurdles to overcome, my lord, which will be difficult. That's why, my lord, this interim order was uncalled for. First, you'll have to establish that the technical bid evaluation is wrong. But in the writ petition, there is no reason why the technical bid evaluation was wrong. On what basis court would appreciate? All that he says is arbitrary. In what manner it is arbitrary? Which clause of the tender was violated? On what basis the learned single judge appreciated the case, my lord? That's why it is said, my lord. at
Nothing,
least-
we are not saying anything to you
Ah.
on merit,
Yes.
but only the difficulty is that the applicant is not here.
At least the order I am submitting for your lordship's kind consideration is, in that case, there will be something left for the petitioner to still, my lord, agitate.
Mr. Chaudhary, you are facing a difficulty. You see, number one, your first point taken of non-joint of necessary parties is a good point. But once we say that, it becomes a order on merit. And therefore, the other side will come and say that you have already formed an opinion and therefore we are prejudiced. That's one. Second is, we have already spoken out that if we pass an order and the work is awarded, then the court cannot turn back and say that, well, this order granted should be, the work order should be recalled. The third thing is that once the situation becomes irreversible, then there's already a decision in the back of the respondent. These are the three factors which are now playing in our minds.
And that's why I was thinking of that part, my lord, subject to outcome of the case. Whether that can protect the interest of the writ petitioner respondent. I'm
But
just
then-
making that.
No, but then you'll have to give an undertaking that
Yes.
if the work order is recalled,
Yes.
you will have petitioner, the appellant will have no objection.
Yes.
You
Yes.
got that?
Yes.
Okay.
Yes.
We both come from a bad place. We can't shake off the lingering effect of the trial court. Third, Mr. Kane Chaudhary, London Senior Counsel, assisted by Mr. TK Mishra. I'm sorry, I'm forgetting. learned counsel for the appellant also heard Hussain Khattal and DSGA appearing for the respondent number
One,
One.
two, madam, 1 and 2, madam.
1 and 2. Next one. By what is this IF?
Hello, one is, my lord, the seeking leave because we are not made parties for vacating the order.
Okay. Leave application is which one?
My lord, 90 is, my lord, stay vacating. 91 is leave, seeking leave.
Which is appended at page 159 of the connected memo of appeal. And it is submitted that the said document was annexed to the writ petition, which discloses that in respect of Namchik, NAMCHIK, West Pole Block, comma, 2 bidders whose names appear at serial number 29 and 30 were technically qualified bidders. Accordingly, it is submitted that the respondent number 3, who had filed the said writ petition, was aware of the interest which has accrued to the said 2 bidders. One being the
Serial 30 is the appellant, my lord.
okay.
PRA
Whereby
Nurab.
at serial number 30, the applicant is the technically qualified bidder. However, the writ petition was filed without arraying the said 2 qualified, technically qualified bidders as respondents. So accordingly, it is submitted that the writ petition suffers from the vice of non-general necessary parties. Next, but accordingly, it is submitted that as the interest of the applicant is adversely affected, leave be granted to file a connected appeal. Next paragraph. It appears that the respondent number 3 has not filed a caveat. Next paragraph. You've heard the learned DSG in the matter. Next paragraph. As the applicant has been able to demonstrate that his interest is adversely affected by the interim order referred above. The court is inclined to allow this interlocutory application and grant leave to the, by granting leave to the applicants to file the connected appeal. This interlocutory application stands disposed of. In, next order will be writ appeal. 17. Simona, now he will be appellant. Next paragraph. This intercourt appeal is directed against the order dated 17/3/2025 passed in WBC 109 of 2025. In view of the nature of stand taken in the memo of appeal, the court is inclined to admit this appeal. By hearing. Next paragraph. Issue notice returnable on. We give a short date on next week.
Yes.
Mr. Chaudhary, when it will be convenient?
Would it be convenient if it is immediately after the vacation?
Yes.
21st or 22nd, Milord? 21st?
2021. For 2025. Next part, the appellant shall take steps for service of notice on the respondent number 3 by registered post with AD. Post in addition, a copy of the memo of appeal along with the connected IA Civil 90 or 2025 be served on the learned counsel who were appearing for the respondent number 3 in the connected writ petition. Next paragraph. In respect of respondent numbers 1 and 2, the learned J accepts notice. So accordingly, requisite extra copies of the memo of appeal. The subdomain in course of the day. Next list also and so 21st. 90 IA 90. Heard. Now Mr. Chaudhary will be applicant. Next paragraph. By filing this interlocutory application from the applicant who is the appellant in the connected appeal has prayed for stay of the operation of the order dated 17/3/2025 passed by this court in WBC 109 AP of 2025. Which is assailed in the connected intra-court appeal. Next paragraph. In support of his prayer for interim relief, the Laureate Senior Counsel for the applicant has submitted that in the list of technically qualified bidders, the name of the which is appended to the connected appeal, the name of the petitioner appears at serial number 30 of the technically qualified bidders. So accordingly, comment is submitted that the connected writ file without arraying the applicant as a party respondent. So according to the company, it is submitted that the proceedings of WPC 109 AP of 2025 is hit by the principles of non-general necessary parties. Next paragraph. by referring to the principles of grants of an interim order, I might have submitted that the learned single judge, though passed an order, the interim order to the effect that the tender process shall not be finalized without leave of the court. But the satisfaction of the court was not recorded as to the prima facie case, balance of convenience or irreparable loss and injury. It is also submitted that the stay was granted by the non-single judge to on the prayer made by the respondent number 3 was technically disqualified. And therefore entertaining the granting of an interim order in the instance of a disqualified person is not sustainable. Next paragraph. It is, however, submitted that in the event the court is inclined to modify the interim order, here's instructions that in the event the order is modified and in the event the work order is awarded to the applicant, would undertake, would give an undertaking that he would not be aggrieved if any adverse orders are passed against the applicant in the connected appeal. Next paragraph. Having noted that no reason has been assigned in the order dated 17/3/2025 passed in WPC 109 AP of 2025 as to why the tender process should not be finalized without leave of the court. And that the court had not recorded its prima facie satisfaction with the entitlement of the petitioner to any interim relief. Court is inclined to provide that the when we provide the interim order, it is 17/3/2025 passed in WBC 109 of 2025, not to proceed with not to finalize the tender without leave of the court. It state However, the says conditional by providing that the finalization of the tender process shall be subject to outcome of the rate petition. Full stop. The order is also on the condition that the petitioner shall, the applicant shall file an undertaking in form of an affidavit before this court.
Miller.
You would abide by whatever directions that may be passed in connected data appeal. As the finalization of the tender is subject to further outcome of the connected data appeal.
Deep,
Now, how much time you had this within a week?
within a week's time.
Such an undertaking shall be filed with on the date of the order.
Miller, we may also be permitted dusty Miller service apart from the normal procedure dusty.
Okay. In the data appeal. You also say that the petitioner shall also serve notice on the respondent by way of dusty. And upon service an affidavit by dusty by routing the process through the registry of the court. And upon service an affidavit of service shall be filed prior to the next date of listing.
Miller.
This in this IA last line would be that the applicant shall produce a certified copy of this order before the competent authorities.
Right.
Just add something more.
Deep.
No, just issue notice on this interlocutory application, which is made returnable on 21/4/2025. So the applicant shall take steps in service of notice on the respondent number 3 by usual process, as well as by serving a copy thereof to the a copy of this application to the learned counsel for the rate petitioner, as well as by dusty mode.
Miller.
By routing the process through the registry of the court and upon service and affidavit of service shall be filed back to the Institute of Listing. Next one. Liberty is granted to the respondent number 3 to apply for modification of the order if so advised. It's list 121/4/2025. Deputy matter. Deputy matter.
May please lordship.
Yes.
My lord, in item number 12, I was supposed to file the reply affidavit, but the petitioner has sent only one copy. Another copy inadvertently has been left out. So he's sending it. So I may be given some time to file affidavit. Rejoinder. People.
No, means sometime is a very tricky proposition. Sometime means till 4:30 or some days.
Some
in the
days.
calendar. Some days, okay.
After, let it be listed after the puja break.
Okay, by when you will be filing it?
My lord, within this week, because he has to send it from Pasigat.
Okay,
One copy has already sent.
okay. Both sides are represented. Mr. T. Patil and counsel for the petitioner submits that due to inadvertence, the affidavit in opposition.
My lord,
Only one copy of the affidavit in reply was sent instead of 2 copies, and therefore the affidavit in reply could not be filed. So the place for an adjournment so as to enable him to file the affidavit. Next, matter stands adjourned today. List on
after the puja break.
After
the puja break, Bihu break.
Bihu break. Okay. List on 23/4/2025. Okay.
Obliged, my lord.
Yeah.
May I please, my lord? My lord, I beg to mention item number 30, my lord.
30.
Yes, my lord, here I am appealing for private respondent number 6, my lord.
Why you are seeking an adjournment? Why you are praying for adjournment?
My lord, I have some difficulty today, my lord. I may be given a short date, my lord. I was out of station, my lord. My lord can fix a date, my lord.
Okay, you have taken consent?
Yes, my lord.
Okay, both sides are represented. The prayer made by Mr. Opadar, Learned Counsel for the private
My lord, 6.
the matter stands adjourned today. List after a week.
My lord.
Okay.
Obliged, man.
My lord, item number 16 may be kindly listed and taken up on Monday, my lord, the 7th. And item 16, my lord.
16. Why this come for orders?
Pardon, my lord.
Why the matter has been listed in orders column?
Yes, my lord, counter affidavit has been filed, and by tomorrow, my lord, I may be allowed to file a affidavit in reply, my lord. And matter may be taken up on Monday, my lord.
So it'll come in admission column.
Yeah.
Okay. Both sides are represented. Other than counsel for the petitioner pays for an adjournment so as to enable him to file an affidavit in reply in the matter. Matter stands adjourned today. List in the admission column on 7/4/2025. Item number 16.
Yes, my lord.
Okay.
My lord, by tomorrow, I'll file a affidavit in reply.
You already allowed.
Obliged.
Lordship, I beg to mention item number 26.
26.
Yes, 26. I'm appearing on behalf of private respondent 4 to 8. Lordship, this matter was fixed on 11th of this month, but somehow without informing me, this matter has come up today. So
This is by orders. Somebody made a mention, I think.
yes, that's
mention was made on behalf of the council, I think, for the petitioner, because matter relates to payment of compensation in a land acquisition matter. These two petitioners, ladies, they are sought to be deprived of their share of compensation on the ground that their father could not give birth to a son. They say that females are not entitled. If there is no son, females will naturally inherit father's property. Now, on that ground, SC has been formed to distribute compensation in respect of this Emily village. We fall in that village. Admittedly, we are entitled. They are saying that 20% of the compensation we have earmarked, only 20%, for these ladies and this unfortunate petitioner.
Let us take up the matter.
no, Lordship, here the thing is, Lordship, on last occasion, it was the respondents who have shown their interest to be matter of the
I will not oppose my learned friend's prayer for objection. Possibly my learned friend wants to say that his senior will appear.
Yes, Lordship.
Everything is all right. Lordship may only direct that the consent should not be disbursed so far as this village is concerned.
But for that also, we'll have to take up the matter. Let the matter reach.
I think, my
We'll consider your prayer if the matter
because
reach.
if compensation has been just been deposited in the month of end of March.
Because
Now, if it is disbursed,
It's
nothing
okay,
will.
not
They did
without
not
any
inform me,
fact.
and my name is not reflected in the policy also, because in fact, I implicated myself, because I am the affected party. They did not bother to inform me.
This okay, we'll take
My
up,
lord,
just
my
give me the prayer when the matter reaches. Let us see what has happened. Yes,
May I please, ma'am? But item number 13, I need to file affidavits, I need some more time.
13.
13 years on 3, so I'm correspondent 2, 3 and 5, 2, 4 and 5.
But you've taken a long adjournment here.
Yes, sir. My lord.
A lot of adjournments have been taken here.
Yes, there have, but I have some confusion. I misunderstood gratitude, she who said it, but claim is regarding pension. That is a difficulty.
Yes.
So for that part, we have to file affidavit.
Just give this item 13. We granted 2 weeks, no further adjournment, otherwise we will hear the matter without your affidavit. Both sides are represented. When last opportunity is granted to the, which department?
RWD.
RWD department to file their affidavit in opposition. So it is made clear that as the matter relates to claim of the petitioner to pension, if the affidavit is not filed, the court will presume that the respondents have, that the RWD has admitted the claim of the petitioner taking recourse to the doctrine of non-traverse, and the matter would be heard on the basis of materials available on record. Next, affidavit of the RWD should be filed positively within 21/4/2025, list on 23/4/2025.
Lovely.
Your Lordship, I would like to mention item number 15. Your Lordship, the matter may be adjourned for today, as the leading counsel, due to some personal difficulties, couldn't appear before this court. I'm for the petition.
List after ensuing view vacation as paid for by land council for the.
And your honor may list after 2 weeks.
It goes after vacation is 2 weeks. Yes.
Yeah, Lordship. Lordship, I beg to mention item number 11.
11.
Yes, your Lordship. Lordship, I am appearing on behalf of SD Roy. Here, the conducting council is Guwahati based. As such, due to some personal difficulties, council is unable to appear before this court.
Okay, list after ensuing view vacation is paid for by land council for the petitioner. Okay.
My lord,
Yes.
I beg to mention item number 25, my lord. On behalf of A. Vishwas, my lord.
25, there is a connected matter.
Yes, my lord. Today I received on the affidavit in opposition, my lord, that matter will fix for my lord, admission here. Yes, my lord, connected matter, my lord.
What is the issue here?
Okay, my lord, no, like, my lord, in behalf of, I am,
Just wait till the matter reaches. You renew the prayer when the matter reaches.
May I, Lordship, I beg to mention item number 10.
Item?
Item number 10. I'm for the
10.
petition. Yes, Lordship. I'm for the petitioner and Lordship appearing on behalf of Mr. P. Tapo. He's currently out of station, so this matter may be listed after 2 weeks, your Lordship.
You have informed the other side?
Yes.
Okay. Both sides are represented on the prayer made by land council for the petitioner. List after ensuing view vacation. Okay.
May I please, Your Lordship?
Yes.
Your Lordship, with the consent of the council for the petitioner, I am trying for the adjournment of item number 28 on behalf of Mr. R. Sekia, Standing Council Information Commission, Your Lordship.
Why it is coming in the orders column?
Your Lordship, service upon respondent number 2, as I've checked the receipts in terms of 29/3/2025, service upon respondent number 2 is served, and Mr. R. Sekia is appearing on behalf of Information Commission, Your Lordship. So some time may be granted to file counter affidavit on behalf of respondent number 1, Your Lordship, Information Commission.
Okay. Both sides are represented. It is submitted that the case is ready as regards service. Next one. On the prayer made by land council for respondent number 1, the matter stands adjourned to enable him to file affidavit in opposition to the matter. List after ensuing view vacation.
Your Lordship, I'm for the petitioner here, and here is an interim order which may be continued.
Interim order passed earlier stands extended till the next date of listing.
Quickly obliged.
Yes.
Your Lordship, I beg to mention item number 8 on behalf of M. Kato.
Yes.
Sir.
You have informed the other side?
Sir.
You've taken consent of the other side?
Sir, Lordship.
Have you taken consent of the petition?
Yes, Your Lordship.
Both sides are represented on the prayer made.
8 and 9 too, sir. Item number 9.
Made on behalf of Mr. M. Kato. Learned council, the matter stands adjourned today. List after ensuing view vacation. Order is there?
Lordship.
Is any interim order operating?
Sir, I thought, sir.
Then renew the prayer when the matter reaches. We are not passing any orders. Renew your prayer when the matter is called. Yes. We are not passing any order right now.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 21.
Item 21.
21, yes, Your Lordship. Your Lordship, the conducting counsel, he is out of station, Your Lordship. He is appearing for respondent number 2, 3, and 4, Your Lordship. Official respondents, Your Lordship.
Okay. What says the representative?
Lordship, this may
But
be.
you have to file your affidavit also. You have filed your affidavit, no?
We have filed our affidavit, Your Lordship.
Lordship, this may be fixed for the hearing, Lordship.
For?
Hearing, Lordship.
Admission.
List
Has
of
it been
hearing.
admitted for hearing? No.
The Lordship, this pleading has been completed and they have already filed reply also. Lordship.
Okay, what says the representative? Okay, it has been submitted at the bar that the case is ready at the guard service and affidavits have been changed. Accordingly, you should rule returnable forthwith without requiring the petitioner to take any fresh steps. Next, this is the matter for hearing.
That's it.
In the month of May 2025. Okay.
Obliged.
Yes.
Your Lordship. Your Lordship, I beg to mention item number 31 on behalf of due to some.
Item number 31.
Yes, sir.
31 is the DRT matter. DRT matters we are not adjourning.
Or enjoy. Yes, sir.
You need the prayer when the matter reaches.
Yes.
Lordship, may I please?
Yes.
Lordship, this is a contempt petition. Earlier, writ petition.
What is the order?
Yes, sir.
Which page?
Page number 13, 12 onward. An operative person is page number 15. Here clearly given a direction by the Honorable Court to the respondent authority to consider my representation. And while I filed a representation, the respondent authority politely refused my prayer. So hence I filed this contempt petition. The rejected order is page number 20. Initially, this writ petition 19 of 2023 judgment order was passed by this Honorable Court, whereby this Honorable Court directed the petitioners to file a representation before the respondent authority, that is Deputy Commissioner Peradado District. And while filing the representation, here clearly direction has been given that the respondent authority shall consider my representation and dispose of within 3 weeks with speaking order. Here, that is the order passed earlier.
It has been passed, rightly or wrongly, an order is passed. How contempt is made out? An order has been passed by the authority.
Yeah. Order passed by the authority.
Where is the contempt made out?
Order passed by the respondent authority, page number 20.
Correct.
Representation. Representation, page number 9.
You see, it's a one-line order, but it's a speaking order.
Yes.
3 retired ALCs were sent to retirement on 34/2022.
Yes.
Therefore, your representation is infructuous.
My lord,
The person is already retired.
yes. As per direction, the para 4 of judgment and order passed by this Honorable Court, page number 15. Here clearly given a 2 order. One order issued, one notification issued by the government 2010-2017, where government of Arunachal Pradesh adopted the FR 56. And after that, in pending of the writ petition 19/2023, the government issued another order by the district administration dated 20 January 2025, where the ALC service retirement shall be effective from.
Where is your representation?
Representation, page number 9,
Page number
page number 9.
9.
Yes. In terms of order passed by the court, I submitted representation.
You don't find that there's a contempt.
Para 4, page number 15, may I read? Here, para 4, clearly specific direction has been given. Kindly, also kindly page 15, para 4. Considering the above position, the instant writ petition is disposed of with a direction to the petitioner to file a concise representation before the Deputy Commissioner Karadadi District Respondent number 2 within a period of 15 days from today, and the Deputy Commissioner, upon receipt of the same, shall within a period of 3 weeks call and dispose of the same by way of speaking order. It is also made clear
have a
that,
copy of this OM of 20 January 2025.
yes,
You have a copy? Show us that copy.
that the copy here, page number 18.
Page 18.
Yes, annexure 4, page 18. Here, page number 19, last para, this order, this notification order will effect from 1st January 2024. On the basis of that notification, the respondent authority reject my presentation. And here, order itself clearly specified, clearly directed that that notification dated 20 January 2025 shall not consider. Only basing of that, not my representation may be rejected, but order dated 2017, that has to be considered. That is notification issued by the government of Arunachal Pradesh, where FR 56 has been adopted. The para 4 here specifically mentioned. May I continue? It is also made clear that the Deputy Commissioner take into account not only OM dated 20 January 2025 issued by the District Administration Government of Arunachal Pradesh, wide memo number so and so, but also wide notification dated 2010-2017 issued by the Department of Administrative Reform, Government of Arunachal Pradesh, wide memo number so and so. Here, my lord, clearly, direction has been clearly mentioned. This notification dated 2010-2017 has to be considered. That notification dated 2010-2017 is annexed along with my representation, which is annexed in page number 16. in this contempt petition. T. Toro.
Mr.
Toro.
T. Torun, then counsel for the petitioner. Non-compliance and willful disobedience of order dated 3/3/2025 passed by this court in WPC 19 of 2023 is alleged in this contempt petition filed under Article 215 of the Constitution of India and Section 11 and 12 of the Contempt of Courts Act. Next, the government counsel for the petitioner has submitted that in paragraph 4 of the order dated 3/3/2025, a specific direction was issued to the Deputy Commissioner Ratadi District within bracket respondent number 2 to take into account the OM dated 20 January 2025 and notification dated 20/10/2017 issued by the Department of Administrative Reforms from the government of Arunachal Pradesh, right, memo number AR-68 of 2010. And dispose of the representation of the petitioner within 3 weeks. They submitted that the speaking order dated 26/3/2025 was passed by the respondent without considering the OM dated 20 January 2025 and 20 October 2017. OM dated and notification dated 20 October 2017. Next correction notice returnable in give a fixed date after 4 weeks. Returnable also. The petition shall take steps and service of notice on the respondent by registered PDD. Next, the pendency of the contempt petition and notwithstanding that the order dated 26/3/2025 has been passed. It shall not be a bar for the respondent to pass a press speaking order within the next returnable date. Next, based on 1/5/2025.
No, see, why
No,
allowed to
it will
take,
be, you have to give more time. Today's second. It will go to 5/5.
well, allow, I may be allow the dusty service also because there is office That is very allowed. Including a normal process.
Okay, the liberty granted to the petitioner to serve notice on the respondent by thus the mode by routing the process to the registry of the court and upon service and affidavit of solution prior to the listing.
May I please, your lordship, my lord?
May I please?
Yes.
But in this case, my lord, item number 2, 3, 6, and 29 are same, my lord.
Yes.
My matter relates to cancellation of the GST registration, my lord.
Yes.
And the coordinate branches and this honorable court has already passed orders for writing the registration. So similar order may pass, my lord. My lord, an order has been annexed in item number 2, my lord. Page number 41.
Yes, 1 and 2.
No,
Sorry, item 2.
2, 3, 6, and 29, my lord.
6 will not be able to pass an order. It has to be adjourned. This in item 6, there is no synopsis. I could not go through the writ petition. Synopsis is not there.
Number 6.
I could not go through it, but these two matters I have read. Okay. Well, Mr.
And Shantanu sir.
S.K. Sharma, Learned Counsel for the petitioner.
The petition.
Also heard. You repeat for all three?
My lord, 2 and 3, my lord.
For the petitioner.
For 1?
For 2 and 3, I am for the petitioner.
Respondent number 2 and 3, my lord.
Who will be for 1?
Oh,
Your name?
Is there.
Behalf of Mr. Thakur.
Your name?
Female.
Just write it down. Counsel appearing on behalf of Mr. M. Kato, Learned DSGI, appearing for respondent number 1. And Mr. M. K. Boro, Learned Standing Counsel for the CGST
and customs.
and Central Excise, representing respondent numbers 2 and 3. Next, brother.
Respondent number 2 and 3, my lord. Respondent number 2 and 3, my lord.
That's what I said.
Yes, my lord.
Next, very brief comment. The case of the petitioner is that he's registered under the Goods and Service Tax Act, 2017 for his firm under the name and style of Mrs. L and L Enterprises. So, the petitioner admits that since July 2020, the petitioner could not file the GST returns. Therefore, the respondent number 3, after issuance of a show cause notice, cancelled the registration of the GST registration of the petitioner's firm by an order dated 8/2/2021. Where is that order? Page?
Page 28.
20?
28.
order dated 8/2/2021. No, sorry, it will be 18/1/2021.
So,
No, no.
it's 8 February 21.
8 February, okay, 8/2/2021.
The lower one is the
Past superintendent, Itanagar Zone Dash Roman 2. Full stop. The petitioner claims that in December 2024, the petitioners filed all his pending GST returns till February 21. And thereafter he applied for revocation of the.
Lords, he could not apply for the revocation. The time was over.
You did not apply.
No, he could not. There's a limited time.
Oh, okay. That was GST returns. And it is claimed that the petitioner has also paid all the late fine and penalties as applicable as on February 2021. So the petitioner could not apply for revocation of the cancellation order as the period of limitation of how much time? Limitation is how much?
Under section 30, it was 30 days plus 60 days can be condoned by the commissioner.
Period of-
So that period.
The prescribed period of limitation and the condonable period had already expired. So accordingly, the petitioner has filed an appeal before the commissioner within bracket appeals under section 107 within bracket 1 of the Goods and Service Tax Act of 2017. However, the appeal of the petitioner rejected by the order in appeal number page 35 numbers so and so dated 17/1/2025 amongst others on the ground that there is no provision in the CGST Act, 2017 to condone any delay beyond the stipulated time under the CGST Act, 2017. So accordingly, the present petition has been filed under Article 226 of the Constitution of India. For setting aside the order dated 8/2/2021 passed by the superintendent, CGST, Itanagar Zone 2 range. Next, by the Learned Counsel for the petitioner is referred to the order dated 24/2/2025 passed by this court in WBC 70 of 2025. in the matter of Miss page 41, Miss Yasang Young Folk versus Inner India and others. I wish this court had passed a conditional order for directing the respondent authorities to revoke the cancellation of the GST registration. Subject to complete payment of all the dues. Next. On a query of the court, the learned standing counsel for the GST has not disputed the position that the present case is similar to the one which has been disposed of by order dated 24 to 2025 passed in WBC 70 AP of 2025. Next paragraph. Similar orders were also passed by the coordinated bench of this court. Including order dated 3 January 2025, passed in WBC 7057 of 2024. Give a dash. Name is Krishnanu, page 43. Krishnanu Botterfield versus Interim India and others. Accordingly, in light of the order dated 24 to 2025, passed in WBC 70 of 2025, and order dated 3/1/2025, passed in WBC 7057 of 2024, where is that order? 28.
41, my lord.
No, 28 is that cancellation. We have to interfere with this. Just accordingly, the court is intent to pass the following conditional order. Give a semicolon, number 1. That subject to conditions hereafter provided, the order bearing reference number, page 28. Reference number so and so. First line. Dated 18 to 2021.
8 February 21.
Oh, sorry, 8 to 2021. Like 8 to 2021. Passed by the superintendent, Itanagar Zone 2, GST. Is hereby set aside. Page 20, 18:1. Full stop. Number 2, the superintendent of CGST, Itanagar Zone 2, within bracket, respondent number 3. will intimate the petitioner his total outstanding statutory dues, if any, in respect of his it is in respect of your firm or your own name?
Lord, that's a proprietorship firm.
No, it is in your own name.
Yes, Lord. It's page number 24 is the registration certificate.
24.
The legal name is the name of the owner. The trade name is the name of the business.
Name of the petitioner having trade name of Messrs. L&L Enterprises. Is the date of cancellation of the GST registration and any penalty or fine as may be found due as on the date of restoration of the GST registration. So as to enable the petitioner to make payment of the entire statutory dues under CGST Act by the petitioner. Next paragraph. Upon a proof of payment being submitted, the respondent number 3 will pass an appropriate order to revoke the order dated 8/2/2021, bearing reference number so and so, and thereby restore the GST registration of the petitioner. It is GST or CGST?
It's GST registration.
GST.
It's a common registration for CGST.
Okay.
It's a common
GST
registration.
registration. Okay. GST registration, not CGST. Accordingly, with the aforesaid conditional order, this requisition stand disposed of. Next, the parties are left to bear the cost.
Let's my name be recorded in the order. In the cause list, it has not come because in the data entry system, my name was not there. My name may be kindly be noted in the order sheet.
We have recorded your name.
Okay.
In the next, we'll pass orders at 2. Item 6, I think there's no.
Lords, item number 3 was also a similar matter.
We'll pass orders.
3 and 29, Lordship.
6, no order will be passed. Okay. Item number 3, we are just in item 2, we have passed an order. In item 2, we have passed an order. It will be same order, only the changes I'm telling you, you take it from. Here the name of the petitioner is Ram Nivas Roj, RAMNIWAS ROJ. His trade name is Mrs. Shri SHRI, Shri Ram RAM Construction Company. The the case of the petitioner is that his business under the trade name of Mrs. Sri Ram Construction Company was severely affected due to the outbreak of COVID-19 pandemic. And therefore, he went back to his native village in the state of Rajasthan and did not file and could not file his GST returns after December 2021. Full stop. Consequently, after issuance of show cause notice, the GST registration of the petitioner was cancelled by order. This is on page 28. Order under reference number so and so, dated 27/5/2023, passed by the superintendent, GST, Pasighat. Next, the petitioner claims to have returned back to resume his business in the month of May 2024 and found that his GST registration was cancelled. The petitioner claims that he has filed all his pending GST returns till May 2023 and also paid the late fine, the penalty. Full stop. However, as the period of limitation as prescribed under section 30 of the GST Act had expired, the petitioner could not apply for revocation of the cancellation of his registration. The period of limitation as prescribed and extendable period had expired. Accordingly, the petitioner has filed an appeal before the Commissioner within Bracket Appeals. CGST, Central Excise and Customs. However, the said appeal was dismissed by order in appeal number, page 33. Number so and so dated 16/1/2025. Just put to the order will be same. The appeal order is here only, which I have said. It will be referred. Okay, we are allowing this repetition at the this repetition stands allowed at the motion stage without issuance of notice of the respondents.
Regarding item 29 is also similar, my lord.
I'll just take it up. 29.
And regarding item 6, my lord, there is a lot of synopsis is not there.
It is same.
6 is also same and 29 is also same. But in this item number 6, there is no
You just in a piece of paper, you give the names and the orders. Who's there in those items?
Item number 6, the petitioner is not present. But item 29 is there.
Yes. Even the date of cancellation is same.
Just write it in a piece of paper and give it. the number of the appeal, your GST registration number, your trade name, the date of cancellation, and the order passed in appeal.
Here, in this case, no appeal was filed before the department because the date for appeal was also exhausted. The
No
limitation
appeal,
was.
right? That no appeal was filed. Okay.
And in case item number 6 may be off, then my lord picks on it, then for April month is not present. Because his petition is not present and there's no synopsis outside.
Item number 6. Item 6, anybody is there? No. None appears in call for the petitioner. However, Mr. M.K. Borod on it, standing counsel for the CGST, Customs and Central Excise is present. Next, we have noticed that the counsel for the petitioner has not submitted a synopsis of the case for which the petitioner could not be perused. We grant liberty to the Learned Counsel for the petitioner to submit a synopsis to the registry for the tag into the record.
Synopsis and list of date, my lord.
Okay, synopsis and list of dates to be tagged with the registry. But to be tagged by the next part. The matter is the motion column as and when the
May fix on 10th of April, my lord.
10th April. My lord. Don't say that. Last thing, so list again on 10/4/2025. Okay.
Item number 4.
Marvelous, man.
You see, you have submitted a representation on 23.
Malad, on 24th,
23, and today you have come.
which is pending before the deputy commissioner, my
But
lord.
in
No,
this 7 days time,
my lord.
there's
But my lord,
one
there
day
is,
there is a restricted holiday, then there is Saturday and Sunday.
my lord. But despite of that, my lord, I am ready to demonstrate, my lord, certain urgencies. Why, my lord? This, in fact, my lord, the already this NIT process was, my lord, completed on 6 January 2025. Thereafter, my lord, same has been kept pending. So my representation is only that, my lord, the result of the NIT dated 6 January 2025 should be, my lord, declared. Because neither my NIT paper has been rejected, nor, my lord, the result has been declared. But despite of that, my lord, other party has been allowed by the, my lord, respondent authority in the interim arrangement, my lord. So, my lord, from that only we come to know that, my lord, this will be lingering for, my lord, another 3 months. Because another 3 months that other party has already been, my lord, allotted. Despite that, this every lingering was done on the part of the, my lord, respondent number
Because
2.
the party which has been granted the contract is not before us.
My lord, because I have a limited period before this, before the lordship, just to, my lord, direction for dispose of the representation, my lord. Otherwise, my lord, my lord may kindly come to page number 17.
Mr. C. Modi and counsel for the petitioner. Also had Mr. Y. Ram and then commended with appearing for the respondents. Next paragraph. By filing this The petition under Article 226 of the Constitution of India. The petition is prayed for a direction upon the Deputy Commissioner, Pasighat, within bracket respondent number 2, bracket close, to dispose of his representation dated 24/3/2025 by a speaking order. Next paragraph. In brief, the case of the petitioner is that the petitioner society you see the petitioner multipurpose cooperative society had participated in a tender process initiated by notice dated 6/1/2025 for selection of PDS rice land route carriage contractor. This is in inverted commas. First off, it is projected that although the petitioner society society's name appeared in the final select list, but the selection process has not been terminated. Public concluded. However, the learned counsel for the petitioner has submitted that the Deputy Commissioner, Pasighat, has made an alternative arrangement for the distribution of PDS rice, stopgap arrangement. Instead of finalizing the tender. Next one. Accordingly, letter notice is returnable on 25/4/2025 be issued. Requisite extra copies of the writ petition be served on Mr. Y. Diran, the government advocate, who has accepted notice for both the respondents. Next paragraph. The pendency of the writ petition should not be a bar for the Deputy Commissioner, Pasighat. No, Deputy Commissioner, East Siang District, Pasighat. To dispose of the representation of the petitioner. The representation dated 24/3/2025 of the petitioner. Next paragraph. Next paragraph, the petitioner, with due instructions to the government advocate. Next paragraph, list on 24. Sorry, 25/4/2025.
Malo, can it be on instead of 25 on 11, Malo? 11 of this.
11?
11 of this one, Malo.
11th of this month.
Malo.
11th, I don't think they will have to, they can communicate and do the needful.
Yes, Your Lordship.
No.
I don't know, Mr. Ram, is it possible for you to communicate within this time?
I can try, Your Lordship, but I'm not, I cannot be certain, Your Lordship.
Okay, but you have to give copies even now. Extra
Right
copies
now.
in the course of the day.
Definitely, Malo.
Extra copies in course of the day. List on 11/4/2025.
All right. Congratulations.
Lordship, we are Ayurvedic and homeopathic doctors in the Ayush, Lordship.
We don't find anything in this writ petition
Lordship,
where you have been asked to practice allopathy instead of your own stream.
Lordship,
It's just giving an emergency duty.
yes, Lordship.
Now, what will a homeopathic doctor do when he's in emergency? He will use homeopathy only. Nobody is asking you to practice allopathy.
Lordship, now normally homeopathic and Ayurvedic, they do duty in the daytime. And there is no night duty, emergency duty. But we are assigned emergency duty. So,
See, you are a doctor.
Lordship,
Doctor cannot say that I would not go to a patient at night.
no,
I will not see a patient at night. In a private practice, when you can see a patient in night,
Lordship.
what is wrong in doing a government
No,
job?
that way, Lordship, if I am asked to go to private house also, I'll go.
No. You see, that is the difficulty.
Lordship,
The doctors are ready for private practice
Lordship.
to go
No.
even at the night.
No, Lordship.
But when in government service, they'll not do work in the night. Why?
Lordship, we are having the risks as because the guidelines and the rules do not permit us. So in case of any casualties, the medical negligence will be heavy actually on us. That is if any legal consequences. Lordship.
That is cannot be accepted.
Lordship.
We'll tell you, I am good in giving horrible examples, but please excuse me for that. You see, let us say that a nurse is there in the hospital.
Lordship.
Correct.
Lordship.
An emergency case comes.
Lordship.
If there's a road accident,
Lordship.
a man is brought, and at that point of time, there is no doctor.
Lordship.
A nurse is there. Now, please tell me, what do you expect of a distress examination of a accident patient when there is no doctor and only there is a nurse available? You forget that you are holding a brief. You just tell us that if this situation happens,
Lordship.
what according to you should be the approach of the nurse?
Lordship, definitely we'll try whatever is possible. We'll try whatever is possible.
Yes.
Only thing is we want that legal sanction. Now, either you allow us by means of order or you desist us from doing that emergency
This is not
duty.
you have been asked to do emergency duty.
This way,
Now,
Lordship.
I would not go to a homeopathic doctor
Lordship.
and expect an allopathic treatment from him. I would not go to a Ayurvedic doctor and expect allopathic treatment from him. But you see, if it is the government regulation saying that the Ayush doctors should also be brought at par and they be given these duties. So what is wrong in that?
There's nothing wrong, Lordship. Only thing is risk factor. We are doing it and we have been doing it since 2007, Lordship, till then. Now, the rules and regulations do not permit us.
Then you see, we are at a greater risk.
Lordship.
In fact, yesterday night,
Lordship.
somebody told me, called me up and said that, oh, your video I saw in the live streaming. What nonsense you are doing? You have passed an order issuing a notice. It's nonsense. You could have disposed of the writ petition.
Now,
I'm just
Lordship.
telling you, you see now the question of risk when you are saying
Lordship.
everybody is at risk. Who is not in risk?
Lordship.
Today, one of the court casual staff, while coming to court, he suffered with an accident and died. He's a contingency driver. I just was informed that this mishap has happened and he has died. So everybody is at risk. How to mitigate it? Please give us a suggestion.
Lordship,
Please give us a suggestion. What could be a safeguard?
Lordship, we are not supposed to give allopathic prescription.
Correct.
So, but in circumstances, we'll have to if we are doing duty. Now, if we don't do that, to Marvi Khaiga, sir, Lordship, the other people, they will slap us. Now, therefore, Lordship, we want legal safeguard. Either you give us the authority by means of notification, or you scrap that duty. That is the only solution, Lordship. So notice, we are praying for notice only on that.
No, it's
ground.
okay. But have you obtained instructions as to whether these doctors, when they are being given when they are instructed, they are not given training on emergency duty? Have you asked the doctors?
No, in that aspect, we do not.
Please ask them.
Lordship, anyway, Lordship, we have made so many representations.
It's okay. Please.
Seeking clarification.
We will tell you. We will tell you.
Lordship.
Just give me 2 minutes. Number one,
Lordship.
under the NABH standards, NABH is National Accreditation Board for Hospitals and Healthcare Providers. They have issued a standard by which emergency department, which can be handled by Ayush doctors, is a prescription. There is a prescription for that. Number two, it is
In 3 states, Lordship, of India, they have allowed, Lordship. 3 states of India, they have allowed. In 3 states of India, they have allowed, Lordship. So either way, Lordship, either you give us the authority or not.
no. When you are given a duty, you already have an authority.
Lordship,
When I became a judge, nobody gave me authority to not pass orders in civil case, not to pass order in a criminal case, not to pass in orders of service matters.
Lordship, our recruitment rules do not say that, Lordship.
Yes, who's appearing for the medical department?
Lordship, I'm appearing on behalf of T. Tagum. The standing counsel is,
Yes.
I could not attend.
What do you say?
As per instruction, let the notice be issued.
Okay, that's your instructions. Okay. Well, uh, Mr. E. Apant and the senior counsel, assisted by Mr. Anju, London counsel for the petitioners. Next part. The petitioners are all doctors. Under the registered under the Homeopathy Council as well as as you call some of the petitioners herein are registered under the Homeopathy Council and some of the petitioners are registered under the Indian System Medicine Act, 2020. And they are generally known as Ayush, AYUSH doctors. Stop. By virtue of notification dated 18/12/2007, issued by the Mission Director, NRHL, Director of Health Services, Government of Arunachal Pradesh, have directed the Ayush doctors to perform hospital duty in the emergency ward and casualty wards. Stop. The learned senior counsel for the next panel, the learned senior counsel for the petitioners has expressed apprehension. Ayush and homeopathy doctors during emergency duty so moreover, the petitioners have also paid for crushing of the Indian order dated 18/12/2007. Next point. issue notice returnable in 4 weeks. Requisite extra copies of the replacement served by the Honored Departmental Council within 2 days. Next paragraph. It is expected that the respondent authorities shall produce instructions regarding the scope of homeopathic and Ayush doctors for performing emergency and casualty duties in hospitals. Next, we'll start at 4 weeks.
Lordship, after
4 weeks.
2 weeks.
4.
Short, can it be shortened, Lordship, by 2 weeks?
2 weeks,
Just-
we have vacation. That's the
Yes,
difficulty.
after vacation.
3 weeks. Okay. Okay, 25. 4. Make it 25. Okay.
Obliged.
Item number 7.
Lordship, this is a very short prayer. Would pray for disposal if possible, Lordship. Because tomorrow is the date fixed for survey, Lordship. For property survey, Lordship.
Let them continue with the survey, that survey. Your grievance is that the gazette notification was not published. That's your only grievance.
Lordship, notification, in fact, we are also in favor of the project. What is pinching us is that they are not following the norms. The glaring example is in the same river, Lordship, downside, another dam is there. They have done the same thing. But till then, construction is already going on, but till then, they have not given the compensation. So, this example is very severe, Lordship. Therefore, we pray that, Lordship, at least under section 11, they should comply with measurement and claims and objections that to be placed before the Gram Sabha, Lordship. That Gram Sabha, they are not doing it. So in Gram Sabha, Lordship, after all, Lordship, we are villagers. This English, Lordship, notification, we do not, as illiterate men, we do not know.
No, but what is the difficulty in carrying out the survey? In survey proceedings, nothing is going to happen.
Lordship, if first determine which are to be taken into survey. Not the survey means, Lordship, there are certain things which compensation is to be given. There are certain things which are not to be given. Now these things are to be and the rate of say for example, Lordship, trees. The rate also is to be told to the villagers, and plus, Lordship, the wildlife, that also is to be told to the villagers. So these things are not told by the government, and simply they will go and take videograph and say we have done the survey, and then legally then
Why you stop? Why you want a survey to be stopped?
we are not stopping the survey, Lordship.
Then
We say that first you come to Gram Sabha, tell the innocent people, innocent villagers. After that, you go for survey. That's what we want, Lordship. Simply we're asking for Gram Sabha.
But that's not the way to proceed. Because if
And-
you look at section 11,
Co-
District Act,
The contents of, Lordship, the preliminary notification.
right to compulsory. Give her book. Yes. Give her book. Right to fair compensation. Give this book.
What is what? What is like?
Yeah.
You're saying that 11.2 is not complied with.
Lordship. Now, Lordship, even the Secretary Land Management, they have written to the Deputy Commissioner in the notification itself, Lordship.
Where is that?
Lordship, may you please to turn page 83, Lordship. They also, Secretary has written that villagers should be told, but they are not doing it. If I may permit to read, Lordship.
Yes.
Now, the Deputy Commissioner, Dibang Valley District Anini, for information and necessary action with reference to his letter number so dated 20th September 2024. He is requested to notify the substances of the notification for public notice at convenient place in the locality along with translation in the local dialect for public viewing immediately and well within the time fixed for filing the objections. The administrative and other expenses shall be borne by district lordship. Now, then again, the Director IPR of Government of Arunachal Pradesh, Naharlagan, for information and necessary action, please. He is requested to publish the above notification to daily local newspapers and submit the bills along with so. This also they have not done, Your Lordship. We have come to know from the.
Please tell me, what do you mean by you are using a word multidisciplinary committee? What is that?
Our own application, Lordship. Our own application, Lordship.
Your name of your committee.
Oh, that was for SIA, Lordship, Social Impact Assessment. The petitioners, they have formed their own group, Lord. Deputy Lordship, sorry. Deputy Commissioner from that committee. That was for different purpose, social impact assessment.
Where's that? But Sapang, you fail to understand.
Lordship.
Number one, you are taking a stand.
Lordship.
In your repetition survey, you have taken a stand that the notification was not published in local newspapers.
Lordship.
Correct.
That's correct, Lordship. The
Second
paper-
stand you are
Lord-
taking.
Lordship, notification, they must have published it, Lordship.
It's okay.
Government must have
Second-
published it.
Second stand you are taking that this compliance of 11.2 was not done.
Lordship.
And three, you're also saying that you are also made a representation that there should be additional survey. How these two things can go together?
Sir,
If there's no notification, and if you are not aware of the,
Lordship, there are two types of survey. One is social impact assessment, Lordship.
yes,
One is property assessment.
yes,
Now, now they are going for SIL, Lordship. Property, property
assessment.
property assessment, Lordship. Now, if property assessment is to be done,
Yes.
now you let us know what is the rate of each tree. Say, if it's cocoon, rate is different. If it's LIC, its rate is different. That way, there are so many things, Lordship. Now, without doing that,
No.
they-
That's not the way. That's what we are asking you.
Lordship.
You see, 11.2 is that the contents of the notification must be informed.
Lordship.
And that you have been informed. That is why you're asking for a what do you call, resurvey.
Lordship.
You see, under no law, cost evaluation can be done before the before a final survey. They can't go and tell each and every person that this is the rate, this is that, and then I'm acquiring. The acquiring notification will not be dependent on that.
Final survey is done, Lordship. Now, what remains is the compensation part.
That they will do, but for that they will have to complete the survey. Only then that can happen.
So that way, Lordship, now the Gram Sabha is to be held to tell those illiterate villagers that these are the things which you have to make assessment. So that is not their, Lordship.
No. You see, under 2, what is required is that you should only inform the villagers of the contents of the notification.
Lordship. To ask, Lordship, this 11 is to be followed.
Correct.
Because they'll have to tell us the pros and cons of everything to our villagers. That is not done, Lordship. Now it is in the paper that this has been done, that has been done. Now, in practice, it is not there. So, if this Gram Sabha is taken up, now what is the harm, Lordship?
I don't know, it's your reading. Paragraph 9 says that you have already raised claims and objections with regard to preliminary notification. How can you raise an objection without knowing what is happening? See paragraph 9, you have submitted representations. How can you do without knowing it?
That we have paragraph 9, Lordship.
In paragraph 10, you write
Lordship.
that they were also issued notice regarding claims and objections under section 11. And then your grievances that the hearing did
Lordship.
not take place.
Lordship, sometime may be given, Lordship. Lordship, so paragraph 9 is concerned, we got it through social media. The petitioner begs to state that after obtaining preliminary notification through social media, Lordship, not in practice, Lordship. We are from Anini, Lordship. Anini Arunachal Times will not reach there, Lordship.
No, but that is not an excuse.
Lordship.
In fact, I have authored a judgment in respect of the bank dues, where somebody has come and said that I don't read that newspaper. You see, the requirement of the law is that not that you must read a newspaper in which it is published. It can be published in two leading newspapers.
Lordship. Now,
this newspaper I don't read, that newspaper I don't read. Is not
now, be that as it may, Lordship. Now, since we have come to know by social media, then what we want is that the authorities, the Deputy Commissioner and others, they must hold Gram Sabha. And in Gram Sabha, they must physically and practically tell us the pros and cons of the construction of dam and environment assessment, impact everything, Lordship. Then only the final.
Please show us from the act that this is a duty which has to be followed.
Lordship, it has to be followed, Lordship.
Please show us.
This has not been followed, Lordship.
No, please.
Section 13, 11, Lordship. Section 11, publication of preliminary notification, the power of officers thereupon. That's okay. They have published it. Now, a notification hereinafter referred to as preliminary notification to that effect, along with details, that also, Lordship, not final notification, preliminary notification.
Yes.
Of the land to be acquired in rural and urban areas shall be published in the following manner, namely, in the official gazette, in 2 daily newspapers. That was not done. Circulating in the local authority as such, of such area of which one shall be in the regional language. Can the government show this? No, they will not. In the local language,
So
in the
on this matter,
Lordship,
we'll issue notice, let them produce this.
Lordship.
But this survey should go on. It will not be, the survey is nothing. If survey is carried out in 2 days, nothing is going to happen. The final notification has not come.
Lordship, compensation will be determined on the basis of that survey only. So may I pray, if notices will be issued, Lordship, may I pray that the survey will be subject to outcome of this petition, Lordship.
Ah, yes.
Lordship. I agree with that, Lordship. In fact, we have filed objection also, Lordship. They have not replied that also. That is pending before the Deputy Commissioner. Since they have not replied, we have come before this honorable court, Lordship.
Let me say, upon the senior counsel assistant, then counsel for the petitioner.
Lots of representation they have filed only on 25 March, Lordship. So it's 1 week only, not 1 week even.
Today's was created on government, senior government advocate, senior government advocate appearing for respondent. All the respondents?
Yes.
Two
respondent was 1, 2, and 3.
No,
four, Lordship.
no,
Four respondents.
1, 2, and 3.
Not all.
But it's okay. 1, 2, and 3.
4, I will not be appearing for.
It's okay. You're saying 1, 2, and 3.
Four is performer, Lordship. Four is performer. It's a company. Performer respondent, Lordship.
The learned senior counsel for the petitioner has submitted that the land of the petitioner
Lordship. Lordship. Lordship, may I? say?
Just a moment. You, Mr. Apang,
Lordship.
this is order by this court and by this bench, where under similar circumstances, this court has held that representative capacity petition would not be entertainable. So it was treated only as the petition by one individual. Paragraph 14. This is the judgment. Because once these people have authorized you, they
Lordship.
should have been joined as writ petitioners.
That's a different question, Lordship. That is obvious question, Lordship. Now, in fact,
Just see paragraph 14 of that order.
Lordship, we have annexed the Lordship.
We have seen that.
Lordship.
But then this is the order. I just remembered that I was searching for it. See paragraph 14.
Even
We allowed this writ petition, but it was treated as only writ petition by one. You see, there's another judgment of Karnataka High Court. I'll recollect it, I will get it. Karnataka High Court has said that in a writ proceedings, order 8 rule 1 is not applicable. So that would mean two eventualities. Number one, a representative capacity writ petition would not be maintainable. The second interpretation can be that a representative capacity writ petitions, if it is filed, the requirement under order 8 rule 1 is that a notice has to be published giving all others the information that there's a representative capacity suit. Even that requirement is not there. So ultimately, because of this, although in this judgment, this Karnataka has not been referred to, but it is for that reason that the writ petition was treated only for one. So treating this to be a writ petition only of one, we are issuing a notice.
Lordship.
Next slide. What did he say in that last para? Before that, you say that the learned senior counsel for the petitioner has submitted that the petitioner has filed this petition in representative capacity, representing the interest of 140 persons who have given their consent to the petitioner to represent them, which is annexed as annexure 1 to the writ petition. Next one. Keeping the issue of materiality of the writ petition in representative capacity open, for the purpose of this matter, the writ petition is treated to be one only by the petitioner. Next paragraph. The case of the petitioner is that his land would fall within the proposed area of Atunli, ATTUNLI, Atunli hydroelectric project, which is proposed on Tangon, TANGON, within bracket Talo, TALOH, bracket close river in Dibang Valley district, which stated to have impact on 7 villages, namely Atunli, ATHUNLI, Ichanli, ECHANLI. This is at page paragraph 2. Ichanli, ECHANLI. Next is only SUNLI. Next is Malini, MALINEY. Next is Apanli, APANLI. Next is Chia, CHIYA. Last is Gunli, GUNLI. The learned senior counsel for the petitioners suggested that the respondent authorities have not complied with the requirement of section 11 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, as the notification, preliminary notification has not been published in 2 daily newspapers circulating in the locality with 1 in the regional language. And it is further submitted that as per the requirement of section 11 within bracket 2 of the said act, immediately after issuance of the notification under subsection 1, Gram Sabha ought to have been called to inform the contents of the notification to the villagers to stop. It is submitted that as the petitioner has not been explained the effect of the notification, the survey of the properties of the petitioner should not be carried out. Accordingly, according to this petition in Article 226 of the Constitution of India, the petitioner is paid for setting aside the preliminary notification dated 4/10/2024 for setting aside the second notification dated 18/3/2025 issued by the circle officer, Italian, the Bangladesh district. And further praying for a direction for issuance of a fresh preliminary notification. And to conduct a Gram Sabha as per the requirement of section 11(2) of the Act. The petitioner has also pleaded for disposal of the representation dated 25/3/2025 by the Deputy Commissioner, Anini, and Anini is Dibang Valley district. Anini is Dibang Valley district.
Dibang Valley, Lordship.
Deputy Commissioner, Dibang Valley district, Anini. Next one. Issue notice returnable on. Yes.
Lots after 4 weeks.
Returnable. Give it fixed date after 4 weeks. For 5/5/2025. This is G8 and additional senior government data accepts notice on behalf of the respondent numbers 1, 2, and 3. So accordingly, extra copies of the petition is served on in 2 days. Next part, the petitioner shall take steps for the respondent note 4 registered post with AB. Next part. The as an interim measure, it is provided that whatever survey is being carried out shall be subject to further orders that may pass in the writ petition. Full stop. The prayer for interim relief shall be again taken up on the next date of listing. Next for a list on 5/5/2025.
Can it be on 8? 8/5.
8/5, okay.
Yes.
8 is a Thursday.
Yes, Lord.
Either 7th or 9th.
Lord, 7th.
7.
Item number 8 and 9.
Obliged.
May I please, ma'am?
Lordship.
My lord,
Yes. Yes.
during the mentioned time, my lord, the matter was mentioned, my
Yes.
lord, by the respondent, the Union of India, my lord. And I was informed by Mr. M. Kato that he has some difficulty. And he asked for my consent and I said, okay, if he has some difficulty, I don't have any objection, my lord.
No, we did not allow the prayer for some reason. Why I forgot. Why did I not allow that to prayer?
No, my lord, I think one of his junior was mentioning the matter. I think the question was whether there was an interim order in the present two applications, my lord.
No, you see, I remember this because on 23 January, we
Madam.
passed an order that it's a matter of 2019.
My
Court
lord.
was disinclined to grant adjournment,
My lord.
but the counsel for the petitioner has left the court. On that day also you were not there because
Yeah, but-
we have passed an interim order. So if we don't hear the matter for quite long time, we'll vacate the interim order. Yes.
Your Lordship, I respectfully pray that to give a next step.
No, it's 2019
last
matter, we
chance.
can't adjourn it. On the last occasion also, we expressed our anguish.
Your Lordship, standing counsel is not feeling well, so he could not attend. And I'm not capable enough to assist the court, my lord.
But it can't be permitted. 2019 matters, you take it for granted despite the last order. And look at the difficulty, we have to read the last order, then keep it in mind, then again reject the prayer, then recall why we have rejected. All this is to be done just because we are hearing a 2019 matter.
Lordship, even I pray for last chance, Lordship, because
can't
land,
permit that.
land department, they used to have a standing council. Now it's not there anymore. So we'll be doing the land department lands matter also, Lordship. I have to go through the instruction they have Lordship given.
Joint prayer made by the land council for the petitioner and the respondents for adjournment, the matters stands adjourned. Thanks, Para. As this is a 2019 matter, and the court has already expressed its anguish by the order dated 23/1/2025. For the grant of adjournment. Accordingly, the parties are put to notice that if any prayer for adjournment is made on the next date of listing, the parties so mentioning would be ready to pay a cost of rupees 25,000. Accordingly, the learned counsel for the petitioner, as well as the learned government advocate and the learned departmental counsel, appearing for all the respondents, shall transmit a downloaded copy of this order to all the, to the petitioner, to all the petitioners and to all the respondents. To bring this order to their notice, full stop. Next para. On the next date of listing, comma, proof of service of a copy of this order to the parties shall be produced before the court. Now, I said parties are present. I write the names, Mr. Opagal, counsel for the petitioner, Mr. Maybe Z8, Leonard, additional senior government advocate, and Mr. Your names.
Teammate also.
Counsel on behalf of Mr. M. Kato. Sir. You are appearing on behalf of Mr. Kato.
On behalf of M. Kato.
M. Kato, done at THGL. Present.
And my lord, I may be submit a copy of the affidavit filed by the land management, my lord. The affidavit filed by the land management, my lord. I have not received it, my lord. And I've been informed that the standing council land management, he's no more, he's relinquished his post, my lord.
Land management, the affidavit is headed by one Binter Picha. His signature is there.
No, well, Binter Picha was the earlier council, man.
Huh?
Oh, thank you.
He's not the council.
No, he's no more the council.
I'll start one.
Okay. Before the last time you said Mr. Opagal and council of the petition submits that. The copy of affidavit in opposition was received by the earlier set of counsel. And therefore, we request for another copy of the affidavit in opposition filed by the respondent numbers 4 and 5.
No, 2 and 3.
Huh?
2 and 3. Deputy Commissioner, we have already started. Land is lordship 2 and 3.
Two and three. When we file any affidavit,
Yes, I can find that. But the petitioner is saying it's in the affidavit, this one. It's not it again.
we don't, at least I don't have it.
Oh.
You check it out. Check this, I don't have that affidavit. We take up another matter, in the meantime, you check up the records.
Lordship, it's a
Lordship,
affidavit to bring on record, Lordship, that much only. This was filed by the standing council, so Lordship.
To bring on record what?
Lordship,
This is to bring on record what?
bring on record, Lordship. Compliance of the Honorable High Court order dated 27/6/2024, directing Land Management Department to place a copy of order dated 8/1/2015. This much only.
No, I was told that they have, the land management filed an affidavit, my lord. So I was surprised, my lord, because I
No,
received that
sorry.
affidavit, my lord.
Lordship, just in a glance, I thought this is an affidavit.
Let me just give it to him.
Lordship,
Give it.
I-
Don't write this part, don't write. Okay, give a copy. Okay.
Obliged.
Like.
This is transfer matter. Malad, the petition was transferred from Bowling to Procedural City Block on 20th October 2024. And thereafter, he has accordingly joined to the place of posting on 6th November. And after joining in the place of posting, the charge was not given to the petitioner, although Deputy Commissioner, District Commissioner, Magistrate has indicated to be taken charge in the joining report. But charge was not given. And thereafter, the petitioner has submitted another application requesting the Deputy Commissioner, who is respondent number 8, to pray for issuance of necessary order for taking
Who's appearing for this,
over of block development
yes.
officer.
Who is appearing for this RD department?
Malad, I am Malad. May I clarify one thing, Malad? It is
Malad,
this misunderstanding arose due to the Malad, order of the Department of Personnel, Malad. There is actually no CO, circle officer, Malad, in the Parsipalo block, Malad. Now the private respondent hearing, Malad, he has been given additional charge of circle officer, which we were unaware, because of which we have posted the petitioner as a video to the Parsipalo. Now, Malad, due to Malad, appointment of private respondent as a CO, Malad, we could not materialize this transfer order. Malad, what happened, Malad?
Get how much cost?
Malad, may I, Malad? There is a subsequent development, Malad. There is one subsequent development, Malad. This is of 19 December 2024, Malad. Malad, may kindly see, Malad. Serial number 16, Malad.
You see, the problem, Mr. Pichara, is that you produce documents, you don't give copies to the others. This is not a top secret.
No,
You
Malad,
don't
I
file
can
an
provide,
affidavit.
Malad.
You don't file an affidavit.
But this is only for Malad information, Malad. What happened, Malad?
When we express our dissatisfaction with the performance of your secretary of the department,
Malad,
you produce this.
This is, Malad, this is the order issued by the Chief Secretary, Malad. What is this, Malad? This is for posting of regular CO, Malad. The private respondent here is not.
I don't know, when you see, when I was wrong in school, when teachers asked questions, I gave wrong answers. My teachers used to tell us, you go back and study from class 5.
Of course, sir.
Now, what will we do for the secretary?
Well, what we want to do, Malad, from this, Malad, is that whether there is a discontinuation of private respondent as a CO, Malad. If there is a discontinuation, we are going to enforce this.
Mr. Nibu is not a private respondent.
No,
He is for petitioner. You solve this problem first, we'll come to the respondent later.
Yes, Malad.
What have you done for Mr. Nibu?
We are, Malad, considering, Malad, we were talking with the personal department, Malad, but there has been no response from the personal department. Now we want to say, Malad, this order, Malad, there is a development.
You just tell us whatever we are requiring.
Malad, yes.
Number 1, have you paid the up-to-date salary to Mr. Nivo?
Yes, Malad.
He's getting his salary.
Yes.
You have given a place of posting to Mr. Nivo?
No.
That is, Malad.
No, Malad.
That is what we are, Malad, trying to resolve, Malad. Because
Malad, this has been more than 7 months now.
Malad, this problem has been created by the personal department, Malad. Because the post is for regular CO, Malad. The private respondent has been appointed as an in charge CO, Malad. So now the in charge CO, Malad, there is also one judicial order in favor of Malad, the private respondent, Malad, in earlier round of litigation, Malad. Now we are, Malad, in a dilemma, Malad, what to do, Malad. So, Malad, because of this subsequent development of order dated 19 December 2000.
Then you are horribly wrong.
Malad.
In the event there is a dispute between two authorities of the government,
Malad,
then the chief secretary should be the arbiter. That is
Yes,
that is what the rules of executive instructions say.
Malad.
Have you told the chief secretary?
No, Malad.
Then how then you don't want to comply with the executive rules of executive instructions?
No. My lord, may I please come to one notification I have already submitted. It is there, my lord, of 1st March 2014, my lord.
First
I
of
will
all,
clarify.
We'll come to everything.
My lord.
But please tell us, when you are giving a post to the petitioner.
We are going through it, my lord. We are processing, my lord. We are about to, my lord, come to the conclusion. But
both the department, you write to the chief secretary.
My lord.
Let the chief secretary take a call. We'll take it up next week.
My lord.
We, after
well-
you, 23rd, we are taking it up. Yes,
my lord, in this regards, they are not aware of the having the post of CO. This particular person, the respondent number 9, who is holding the post of CO cum BDO, has been holding as a in charge for more than 12 years, more than 11 years, around 12 years now. How can there be any possibility that he department director, head of the department is not aware of
that
the
is
fact?
not the subject matter of challenge.
That is one aspect. And the deputy commissioner on the record, it appears that, my lord, one thing I would like to appraise before this court is that on the joining report, which is page number 22, annexure C, 23, my lord, 23. Deputy commissioner has already indicated charge to be handed over by the incumbent. This was the situation. Then thereafter, it was no response was came. From there, we understood some problem was there. That is why we have written a representation that is in page number 26. Representation to the deputy commissioner, a request letter to the deputy commissioner, praying for issuance of necessary order for taking charge over the block development officer, BDO, charge against CD block Parsiper law. Then it was submitted on 21st, and now it has been observed that one political interference is there in this regards. That is why the respondent number 9 is holding charge for around 11 more than 11 years. And on 22nd, one letter was written. My lord, this is unofficial. Although it is unofficial, I want to appraise before the court. MLA of the area has written to the chief RD minister for cancellation of the
You see, I have a
order.
personal liking of accepting documents without being filed on. bail
Yes,
and
that
affidavit.
is I humbly
You see,
I understand. This was written, and thereafter all this lingering system process has been going on since last 7 months. This is the factual thing that is going on.
But you have not
Interference of
stated-
the political
You
interference.
have not stated this fact in the writ petition that somebody is holding charge for last 11 years. We can't take cognizance of oral statements. Please try to understand. Or you give an undertaking by way of an affidavit that when you appear for respondents, you will never object to any submissions made by the learned counsel for the petitioner when he's speaking from outside the record. If I have a personal affidavit that when you are the counsel, you will never object when the other side relies on an unsubstantiated statement. We'll ask the registry to accept it and then we'll accept your statement. You can't do it, Mr. Nivo. Statements, you don't bring it on record and then you want us to take cognizance of those.
Just undisclosing the fact that it was a political,
if I do
it's a
it-
political interference.
If I do it, you will be the first man to go outside and laugh at me. I can give you a guarantee. Once you go out of this room, you will laugh. I made him a fool.
Normally, this is the harassment that is facing by the petitioner.
So the
not presently.
unsubstantial thing I described.
Yes, my lord, I understood that.
Yes.
My lord. My lord,
You
even
go
my
to the
lord,
chief secretary, he'll do it within 15 days and then report to the court what he has done.
my lord.
You have not filed an affidavit.
My lord, we are processing whether to post in the same post as an in charge video or we should remand him back. My lord,
Don't think very too much.
my lord,
Somebody may have brain tumor.
my lord. Yes, my lord.
No, don't think. When you don't have the capacity to think,
But
don't think.
we are also contemplating now to enforce our order, my lord.
You
Why?
You want me to write this in the order sheet?
No, my lord.
That the secretary should not think much. If he sends, he issues transfer order without knowing where to post someone,
The problem, my lord, is that my lord, this CO.
will direct the chief secretary to take up departmental action against the secretary who does not know how to manage his department.
No, no, no.
I'll pass that order. You just note that I'll pass that order. This secretary is in deep trouble.
Right.
If you keep on thinking,
Right.
tell the secretary he is in deep trouble.
Right.
He'll come to know in 5 minutes.
Actually, the problem is because of the personal department.
We'll tell you, he must know how to manage. If he has no administrative capacity, don't make him a secretary. Make him a peon. No, I'm not joking. I'm not taking a lighter note. But we don't want officers in the state who don't know how to act. If they don't know management, don't be there. There are many people who forgo promotion.
Yes.
But I can't handle that post, I forgo my promotion.
Yes.
Then downgrade this man to where he does not have to take any decision.
But last chance may be given to us, Manoj, so that we can resolve the issue, Manoj.
You won't be able to. The secretary has no managerial capacity. He is not fit to be an administrator. And I'll send it down to the chief secretary. Let him decide the fate of this man.
Yes, ma'am.
He issues a transfer order and doesn't know how to post him. He issues a transfer order and somebody is not complying with it. And he does not know he's.
Manoj, we have already processed, Manoj. It is with the minister now, Manoj, concerned minister, Manoj. Minister RD, Manoj. But
You're mortgaging your conscience to a minister.
no, Manoj.
Then what will a minister do in transfer orders? Please tell us.
Our
We
concern
are recording this in the order.
No, Manoj.
The state, everybody in the state should know that the secretary does not pass an order, goes to the minister, waits for his approval. No,
Last chance may be given to us. Manoj. 2 weeks, Manoj.
you please think over and tell us. Whatever you are trying to tell us, we'll record in the order.
Only 2 weeks may be given so that we can resolve the entire issue, Manoj.
But you will not be able to.
We will try our best, Manoj.
No, trying our best is a wrong
We will resolve
statement.
it.
It's not only a wrong statement, it will be unviable statement. If the personal department is put in, you cannot do anything.
Otherwise, Manoj,
Can you tell me a way what your secretary can do when the personal department has stepped in?
this,
No, you don't know.
Manoj, the appointment of CO has, Manoj,
You privately asked Mr. Mazumdar, he's sitting silently behind. You ask him what can be done. The personal department or finance department puts their foot in. You can't do anything. The only respite is to go to the chief secretary.
at least last chance may be given.
Another direction may be given.
These are two very heavyweight departments. Personal department and this finance can't do anything. Mr. Mazumdar, am I right? I'm throwing. Huh? I understand. Home and all you can manage. These two departments is very difficult.
But by such only observation, we may be given only 2 weeks time, Manoj, so that we will push
You
the
will not be able to. Mr. Kisai, you can go out, speak to your secretary and then come back. We'll take it up after 10 minutes. You go and speak to him. Have a very clear picture. Then tell us.
All right.
For the same,
Well,
for the same settlement, they have already, last time they have already taken 1 week time.
that's okay. Let Mr. Picha ask. We have no grievance against Mr. Picha. We depend on him. But we don't have this faith on the secretary. On Mr. Picha, we have faith. Mr. Picha, just speak to them and come out. You ask him how is proposing it. If it does not want to go to the chief secretary, how does he want to do it?
Yes.
I'll tell you what his reply will be. His reply would be that we have asked the minister concerned, and minister concerned has given us a few days time to think over and tell us. That is the only reply he'll be giving you. You can go out and ask him and come back. But we don't. We can't do that. There are reasons for it. We'll disclose more in the order. Next matter. You just call him and take instructions because we are recording it. Whatever you want to record, we'll record in the order. No chalta hai business.
Item number 17.
My lord, they took time to file affidavit.
If they don't want to, yes, for the respondents, no affidavit is filed, we allow the writ petition. You dismiss the petitioner from service. Who's the respondent?
Respondents are all fine.
Yes, Mr. Luan. You dismiss this petition from service.
Main party is the department.
Huh?
There is counsel for department.
Mr. Prakash, where is the impugn order? Which page?
Which order, madam?
Impugn order which you have impugned here.
Or impugn order? Impugn order is, madam, there are two orders. Initially, we moved the writ petition, and direction was given to consider my case by way of personal speaking order.
No, just tell me, where is the, first of all, where is the contract between you and service teacher?
Oh, appointment.
You're a contractual teacher,
Yes.
right? When did your contract end?
Hello, madam, they say now that they scan their contract expired. But when in case of earlier writ petition, they did not take a scan. In impugn order, present impugn order, they say their contract is no longer in existence. My lord, I was terminated from service on the basis of on the charge of a misconduct.
Mr. Prakash, sir,
When we challenged that order initially by filing a writ petition in
Mr.
2004.
Prakash, sir, whatever has happened in the earlier writ petition will not change the nature of appointment. Your appointment was a contractual appointment. That agreement is not here.
Even during the, my lord, tenure of the appointment, if a person is sought to be terminated on the basis of the charge, unauthorized absenteeism is itself is a misconduct. Therefore, they are supposed to hold an inquiry. That was the, my lord, basic stand we have taken in our petition in support of our challenge. That matter was, my lord, demanded back to government to reconsider the matter. Then they straightaway arrived at a conclusion that since the appointment is no longer in existence, an appointment was a contractual appointment.
You see, I have many questions to ask you.
My lord.
There's another question.
My lord.
You see, in this order at page 56,
My lord.
it is mentioned when you are found absent,
My lord.
the authorities give you a show cause notice. And then you give a reply that there's lack of basic facility, electricity, drinking water, kitchen, and
Yes.
therefore you are suffering from depression.
Yes.
Correct. Now, have you given any statement in the writ petition that you are out of depression? You are no longer suffering from mental problem of depression?
Lord, that sort of statement is there, my lord. Lord, there is only a single teacher, 5, my lord, classes. The number of 5%, number of
But you see,
students are there.
if somebody admits that he is on depression, we can't allow him to teach students.
And he approached the authorities to, my lord, appoint another teacher. He arranged my quarter. There is no electricity, no water facility. And in that situation, my lord, he suddenly fell ill, he came back to Itanagar. Then
You see,
he
the third question is that while you are absent, in the year 2014, you did not take the annual examination of the students.
That was the allegation, my lord. Even if there is some allegation, at least I should have been given some sort of opportunity so that I can give a better explanation. This is the charge.
You still want charge sheet on this? When you don't take examination, you want charge sheet?
How far factually it is correct, my lord? 'Cause,
is to review the amount of allegations. Even contextual appointment, they are equally entitled to get at least an opportunity. If 311 is not applicable,
Where is the statement in your writ petition, which date you have received your salary? Last salary was allowed to be withdrawn on which month? You know something, there's something more. We put a second question to you about depression. Now, please come to page 65. In page 65, you say that a rigorous traditional puja was conducted to boost up my lost mental and moral strength,
yes,
to free myself from suffering of agony and anxiety that led me to extreme depression, since failure to qualify in all the attempts of APPSC examination from the year 2003 onwards. From the month of July 2014, with beginning of chicken liver examination, in search of knowledgeable local traditional priest, Muslim mullah, and Hindu Nepali tantric priest. During the process, I was at my native village, Sikki Rijo of Lagi Gamlin village, under so-and-so.
mentally, my lord, so he made both.
I don't know, it's your statement. I'm just reading it. If you have lost your mental states in 2003,
Possibly, my lord, he will be very.
and you have failed in all APPSC, I don't think you will be fit for a teacher.
He must have written all this thing. He, basically, my lord, he innocent person, and innocently he has written all this thing without knowing the consequence.
Looking at the future of students, then you say that I stay in Itanagar. I started traveling on a motorcycle from Itanagar to the place of the school, and therefore he could not do duties. So every day you have a capacity of driving 120 kilometers.
Not possible.
60 plus 60. And then obviously you can't do any duty. You could not take examination of students.
That's why he sought for a transfer.
No, I'm sorry, Mr. Prakash, we don't find any merit in the petition.
Even then, my lord, at least, my lord, let government, my lord, file an affidavit.
We don't require an affidavit. When your contractual service is terminated, section 14, clause D applies of the specific relief act. You're not entitled to any relief.
No, my lord. My lord, once my right is taken, my lord, so to be taken away. At least I have a right, my lord.
This petition would not be maintainable.
Earlier occasion, my lord, matter was remanded by court. Court was not inclined to examine the matter. Court said that the matter be sent back to government, and government will take a decision.
Terminated employee, what decision the government will take? No, I'm sorry, we are dismissing the petition. Mr. A.K. Professor Learned Counsel for the petitioner. Also heard Mr. N. Luang Learned. N. Luang Learned Senior Government Advocate appearing for the respondent numbers 1 and 12. 1, 1 and 12. 2 and 5. And no, 1 and 5. 1 and 5. No, 2 also. School education, you are not appearing?
I'm appearing.
You are appearing.
2, 3, 4.
And Mr. I'm sorry, I'm unable to catch your name. The Learned Counsel, appearing on behalf of Mr.
T. Tagu.
T. Tagu, Learned Standing Counsel for Education Department, representing respondent numbers 2, 3,
and 4.
and 4. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the termination order dated 25/6/2014 order number page 56, order numbers also dated to okay, by which
Going to dispose of the matter or dismiss?
yes, by which
But then Lordship may kindly record my submission.
yes, I'll definitely record you make your submissions.
And at the same time, government is filing an affidavit in spite of.
We'll record that. Terminate the service of the petitioner with immediate effect under CCS within bracket temporary service bracket close rules of 1965. Yes, what is your submission, Mr. Professor?
Lord, first submission is that, my lord, since the government failed to provide any sort of facilities to its employees, therefore it was hardly possible on his part to, my lord, continue to serve. He made several representations before the authority to at least to provide the facilities. Government didn't bother. Then he, my lord, suddenly fell ill, and that was the reason he could not attend the duties. And when we, my lord, filed the initial petition, court was, my lord, about to pass an order, but court says since government didn't take any decision, let the matter go back to government for taking appropriate decision. And
Where is that
government
order? Which date is that order?
my lord, that was the order. '67. There are 4. The submission made by standing also. The education department has submitted that all representation made by the petitioner was not before the proper forum. He has also contended that such representation which have been placed before the deputy commissioner from district to the director of school education department ought to have been submitted before the competent authority. The deputy commissioner from district to the director of school education, Dr. Natal for the eternal. Referring to the letter or termination and annexure appended to the petition, it has been contended by the Learned Standing Counsel for the Education Department that annual examination of sources could not be conducted due to his prolonged absence from the said school, which seriously affected the teaching environment of the school and hampered the academic life of the student. And he violated the contract agreement also. The petitioner being a contractual appointee didn't deserve any prior notice from the time of his termination. However, it is submitted by the learned counsel for the petitioner that opportunity should be given for filing proper application before the competent authority. That is wisdom. Heard the submission of the learned counsel for both the parties and the petitioner who has been terminated from service should be given an opportunity to place the matter before the appropriate competent authority to consider his grievances for the answer justice. Taking into account of the above fact, the petitioner is allowed to file proper representation addressing all the grievances within 7 days from today because the Deputy Commissioner on district project.
It doesn't make a point. The speaking order was passed thereafter at page 77.
Yes.
Then
And if I am still agreed by the speaking order,
we've taken note of that.
and therefore we have challenged this order by finding the present.
Yes.
Now, my lord, sleeping order dated 2/12/2021.
Yes.
Or she will find it at page 677. I'm going to read my lord. It is, one.
We have read that. Only after that we are saying that your contract was already terminated. That's why we asked the question.
But the petitioner has not shown.
Petitioner is also assailed the
That-
order dated 2/12/2021.
He has no legal right to claim for further employment. I think Shobha notice is not.
So we have read that, Mr. Prakash, you did not read it.
Pardon, my lord?
We have read that, you did not read it. We just make your submissions.
Therefore, my lord, the way they have disposed of the entire repetition, my lord, the representation, that is not in conformity with law. Because they have got the charges and charge ought to have been proved. By way of, my lord, department proceeding or some sort of inquiry. These are personal findings of the personal conclusion of the authority. And it is not, my lord.
CCS rules. No, this one.
It is not right to say, my lord, that contractual appointees, they are equally entitled to, my lord, to be heard in a department proceeding. Because you have got the charge, you have to prove the charge. Simply by, my lord, disposing of a representation, it cannot be said to have been decided properly or heard properly. That apart, you was, my lord, never served with any notice. Any article of charges or brought to his notice, you were never asked to submit his reply against the proposed charges.
Speaking order dated 2/12/2021 passed by the Deputy Commissioner, come. DPD. What is the full form of DPD? DPD, comma, ISSE, comma, Papumpare District, UPR. Next one. The learned counsel for the petitioner has submitted that the service of the petitioner was serving at the relevant time as an assistant teacher of, what is the name of the school?
Common Public School, Ruchi.
Government Primary School, Rushi, RUSHI. Stop. The service of the petitioner was terminated by an order dated 25/6/2014 on charge that the petitioner was absenting from his place of posting and he was accused of dereliction of duty. Accordingly, the learned counsel for the petitioner submitted that once the petitioner is sought to be terminated from service on specific charges, it was incumbent on part of the respondent authorities to hold a departmental proceedings.
Today, in fact, my lord, what you kindly appreciate. They are supposed to file affidavit today. To that extent, my lord, I prepare with it. Decisions are also not available with me.
You see, when you take an adjournment, take it at the first shot.
No,
not after commencement of
I
the.
already, appraisal lordship that they did file the affidavit.
I'm sorry, Mr. Purkar, sir.
Otherwise, it will be, my lord, something wrong on my part.
We'll take note of that. We'll record your submissions.
The lordship goes, that get contextual according, they are equally entitled to get some notice. Now, our high court also decided this question. Today, I am sorry. I did not have the knowledge that we are going to, because Takum, yesterday evening, Takum told me that, my lord,
Mr. Purkar, sir,
affidavit.
today, please take knowledge that when you are in before this particular bench,
My lord.
I am ready for hearing at the motion stage. I am ready for hearing at the admission stage. I am ready for hearing at the order stage. I am ready for hearing at the hearing
That's right.
stage. Correct.
My lord, that's right.
Takum
Yesterday, I had.
If in this many years you have not acquainted yourself with that.
Takum yesterday evening, when I had talked to him, he said we could not file the affidavit, so we are going to take time. Today morning also inside the court, they
See,
also.
am I bound with his submissions?
Oh, my lord, I think, my lord, there is a lapse on my part. If I cannot argue matter properly with full preparation,
No.
there will be something wrong on my part towards my client, madam.
After having spent more than
That's why, my lord,
45 minutes,
at the outset, I have appraised your lordship.
we are refusing.
Then, of course, my lord, I have nothing to say.
Postpone. The second submission made by the learned counsel for the petitioner is that the departmental counsel had sought for his consent for an adjournment on the ground that affidavit in opposition could not be filed, and therefore he is not ready for hearing. Full stop. Next, the other submission of the learned counsel for the petitioner is that in the earlier round of expedition, by the petitioner, an order dated 27/2018 was passed by this court in WPC 88 AP of 2017, whereby this court took cognizance of the grievance of the petitioner that as the petitioner has been terminated from service, he should be given an opportunity to place the matter before the appropriate competent authority to consider his grievances. And accordingly, the petition was disposed of with a direction of allowing the petitioner to file a representation within 7 days from the date of the order, and the Deputy Commissioner from District Project Director from Education Department, Papum Pare, was directed to consider and dispose of the same in accordance with law. Accordingly, it is submitted that the consequent order which was passed by the said authority on 2/12/2021 was not in accordance with law, as all the grievances of the petitioner was not addressed. Next, the learned counsel for the petitioner has also submitted that from the day the petitioner had joined the government primary school, Rushi, he was not provided with the appropriate facilities and the and his and the place lacked electricity, drinking water facility and kitchen, which led to his depression. And that despite several representations, the said facilities were not provided to the petitioner. Next, brother. Mr. Professor, have you annexed any document regarding your any document relating to your illness? Somewhere you have alleged that you became ill and you had gone to hospital. Somewhere you have said it. Have you filed any medical documents? No. No. Next one. It is further submitted that as the respondents have not filed any affidavit, from an opportunity the respondents be directed to file their affidavit, and therefore the matter ought not to be disposed of at this stage. Next paragraph. Consider the submissions made by the learned counsel for the petitioner and also peruse the repetition and the documents appended thereto. Next paragraph. In the termination order dated 25/6/2014, it has been mentioned that as per the school visit report submitted by the SMC of Government Primary School, Rushi, Cluster Resource Center Coordinator, Circle Officer, SANGDUTOTA, dated 2/7/2013, 17/4/2014, and 23/12/2013, substantiated that the petitioner was absenting from his place of posting without authorization of the competent authority since 9/7/2013, which had hampered the academic functions of the school. The petitioner was it is also mentioned that the petitioner was issued a show cause notice as to why his case should not be recommended for termination from the post of assistant teacher within bracket SSA. Full stop. As per the said order, and these replies submitted by the petitioner on 17/1/2014, there was lack of electricity, drinking water facility, and kitchen. And therefore, the petitioner suffered from depression, stop. It is further mentioned that as per the reports, the petitioner has not conducted annual examination of 2014, which had hampered the academic life of many students. And accordingly, it was held that there was clear violation of the contract agreement. And therefore, as the appointing authority, the Deputy Commissioner, District Project Director, Papumpara District, had terminated the service of the petitioner with immediate effect under the Central Civil Service within bracket Temporary Service bracket close rules, 1965. Full stop.
Madam, paragraph 22, my lord, I have made a positive statement, madam, justifying that the notice they, my lord, they are claiming to have issued notice. But I have made a statement that justifying that that particular notice cannot be treated to be notice because it was not addressed to me. And I took a positive stand that no any such legal notice was ever served to me. Thereafter, I approached this report. Paragraph 23.
Where is the document? That document is not produced. Where is that notice?
That cannot be said to have valid communication, nor can it be said, cannot be acted upon against the petitioner so as to take any such disciplinary action against him on the charge of unauthorized actions. So when the petitioner, prior to date of issuing the notice, oppose this honorable court and file a writ petition challenging the implement action of the responding authority in terminating his service on the alleged charge of misconduct or unauthorized action and deviation of duties. That apart, the petitioner, before approaching this honorable court, not only personally apprised the responding authority.
You see, those statements are not cannot be gone into number one. In the earlier writ petition,
Yes.
this court recorded about the termination order. It
Right.
recorded your stand. The court did not record that the notice was not served to you.
Earlier decision was not even hard on merit. Simply
That we
matter
don't
of
know.
refer to.
That we don't know, but you are raising a point which ought to have been raised in the earlier writ petition.
Even then, my lord, Lordship kindly.
Second is that you submitted a representation.
Yes.
After that,
I said I
after
submitted
that,
several.
in that representation, did you take that ground that notice was never served?
Just let me-
Let me complete the order, then you tell us, we'll incorporate.
Right.
In In one of the representations submitted on 25/7/2018, the petitioner has admitted that after joining Ruchi Primary School, he was unable to perform his duty on the ground of his prolonged illness. And he has admitted that while he was teaching in the school, he was suffering from mood disorder. And therefore, he was compelled to leave the school for his treatment, allegedly by giving verbal information to the chairperson of the school management committee. So he has also admitted that he was compelled to leave the school for a few days for checkup when his health deteriorated. And therefore, he could not inform the controlling officer for more than 12 days of his absence. It is also admitted that as he was suffering from mood disorder since April 2012, he could not resume his duties. And could not avail any kind of leave except 12 days of casual leave from his controlling officer. Full stop. In an appeal for review of the termination order submitted on 25/9/2014, The petitioner has rigorous traditional puja was conducted to boost up his lost mental and moral strength. To free himself from suffering of agony and anxiety, which led to his extreme depression. Since failure to qualify in all attempts of APPSCC examination from the year 2003 onwards, and then he had also searched for traditional priests, mullahs and tantric priests to cure him of his for his cure. So the petitioner has also referred to his the medical condition of his father, chronic sickness of his minor son, for which he had to take his father and son to treatment at Delhi and Itanagar respectively. And thereafter he was transferred to the government primary school, Rushi. As he was not provided with the appropriate facilities, the petitioner started to come from Itanagar by a motorcycle of his brother-in-law, covering more than 60 kilometers up and down. And due to weather conditions, the petitioner was prevented from carrying out his duties. And as the APPSCCE examination, 2013-14 was coming near, the petitioner was compelled to stay in Itanagar. The petitioner has further stated that these factors had destabilized his mental ability and derailed his power of vision and reasoning. Good stop. First off, it may be mentioned that while in the text of the appeal for review of termination order, which was filed on 25/9/2014, the petitioner stated that he had to take his father for treatment at Delhi. First off, however, in the documents annexed, in the reference to document annexed, the petitioner has appended the documents of his father-in-law's treatment in Delhi. First off. Next one. From the contents of the speaking order dated 2/12/2021, it is clear that it has been clearly mentioned that the vacancy which arose from the termination of the petitioner from his contractual post of assistant teacher within bracket A, bracket closed, public PRD under SSA was filled up after his termination and no vacancy was left for reinstatement and First off, The authorities have also mentioned that as the contractual service of the petitioner was not renewed in the year 2014, he had no legal right to remain in service without extension of his contractual service. Next one. On the perusal of the provisions of Rule 5 1 of the CCS within bracket temporary services bracket close rules for 1965. A service of a temporary government servant is liable to be terminated at any point of time by a notice in writing given either by a government servant to the appointing authority or by the appointing authority to the government servant. And the period of notice prescribed is 1 month. Therefore, at best, the moreover, under the provisions of Section 14 within bracket D of the Specific Relief Act, a contract which is in its nature determinable cannot be specifically enforceable. Therefore, as the service of the petitioner was terminated, at best the petitioner would be entitled to wages for the notice period. Wages of the salary for the notice period. The contractual appointment of the petitioner having not been extended after and in the meanwhile, the service of the petitioner having been terminated on 25/6/2014. The service of the petitioner cannot be restored back. Next, but it is not the case of the petitioner that the conditions of the condition of service in the school has changed, or that the petitioner has come out from the depression. Moreover, when the allegation against the petitioner is that he did not conduct academic examination in the year 2014, and when the petitioner has already admitted that he has not attended school for some time, for some period of time in his representation, the absence without intimation, prior intimation to the competent authority, or taking or revealing of the regularization of leave post facto, the termination of the service of the petitioner on ground of non-extension of the contract cannot be interfered with. At this stage, after 11 years of termination of service. Next one. In the earlier round of rate petition, when this court had disposed of the proceedings of WPC 88 AP of 2017 by order dated 27/2018. The termination was not interfered on the ground that the departmental proceedings against the petitioner was not initiated. So rather, the petitioner was permitted to send a representation, to submit a representation to be disposed of by the Deputy Commissioner cum Director, a District Project Director of Papumpally District. Sorry, it will be District Project Director, Education Department, Papumpally District. From the said authority as passed a speaking order wherein it has been mentioned that the contractual service of the petitioner was not renewed after the year 2014. So moreover, in this state petition. There's no period for extension of the contract of service for a period beyond 2014. The petitioner has not been able to make out a case for reinstating him in service and to give all consequential benefits from the date of from 25/6/2014, or the date of his termination, till his reinstatement. Next paragraph. In respect of the submissions made by the learned counsel for the petitioner that he had given a consent for adjournment, the court would like to state that whatever transpires between the counsel for two sides is between them, and the consent given by the counsel for one party would not bind the court to grant an adjournment just because the parties have accommodated, have made an arrangement for adjournment. To stop. Secondly, on an impression that the matter would not be heard, it is not a ground for adjourning the matter. In this case, the service of the petitioner was terminated in the year 2014. And this is the second round of litigation by the petitioner, and the present date petition was filed on (13/6/2022). For more than 2 years, the respondents have not filed an affidavit in opposition. This status would not dissuade the court from hearing the matter and with the intent of its disposal. So accordingly, the objections made by the learned counsel for the petitioner for taking up the matter for hearing is repelled and rejected. Yes. This. So according to the contestants, the court having not found any merit in the matter, the petition stands dismissed. Under these circumstances, there shall be no order as to cost.
What should I impose cost?
No, no, no. Unless you want.
It's okay, my lord. This is the fifth for this.
Next item.
Number 1930.
Yes.
Yeah, Your Lordship. Your Lordship, I'm appearing on behalf of the Canadian Council, Mr. B. Koshik from Guwahati. Your Lordship, he couldn't make it today, so I've been instructed to pray for listing the matter after Bihu vacation.
Lordship, if they are not going to file rejoinder, matter may be fixed for admission hearing, Lordship. Next.
Is the pleadings exchanged?
Yes, Lordship. Respondent has also filed, private respondent has also.
We don't know. A simple question is whether the pleadings are exchanged. But when you take up when we hear the matter and the admission said, then you can't say that the pleadings are to be exchanged. Tell us.
That part, Lordship.
No, you are asking for the matter to be listed in the admission column. Therefore, I'm
Yes,
asking
yes,
you,
yes, Lordship.
is the pleading exchanged?
Our part, Lordship, we have done, we have filed our affidavit.
Yes.
Your Lordship, the conducting council is not here, so I'm not
No, I
aware.
understand, but you must know whether pleadings are exchanged or not. You see, you have a long way to go. Therefore, when you are before the court, you must know these things. Otherwise, you may be in a tight spot.
Last occasion, they wanted to file rejoinder, Lordship. Till now,
Okay.
they haven't filed.
All sides are represented on the pair made by learned counsel for the petitioner. The matter stands adjourned today. Take note, next paragraph, we take note of the fact that as per order dated 12/8/2024, it is recorded that no rejoinder affidavit has been filed. As per office note dated 1/4/2025, rejoinder affidavit has not been filed. Therefore, it is presumed that the concerned party has given his right to file any rejoinder affidavit. So accordingly, list this matter after answering view petition in the admission column. Any affidavit which is filed without the leave of the court shall not be made a part of the court.
Obliged.
Next, the learned counsel for the appearing parties shall transmit downloaded copy of this order to the concerned arguing counsel. After that list, after this. Next.
Item number 14.
Yes.
But I have spoken, my lord, to her, my lord, our secretary. I have been informed that just transfer of the petitioner has been processed, Madam. And the file is with the Honorable Minister, Madam. So we have, one of the secretary has called back the
But
file.
what will the minister do? Please tell us. Under the rules of executive business of state of Arunachal Pradesh, why this file should go to the chief minister, the concerned minister?
Well, he is the executive head of the department, so Madam.
Executive head, minister
Of the department.
of the department.
Yes.
Will you please show us which authority makes him the executive head?
Well,
He's a political head.
I cannot say, Madam, but because of that, the file has been processed has been moved to the secretary.
Executive of the state will only be executive. A politician cannot be executive. If the state is,
Madam, can this matter be?
I don't know, we all read in the constitution that there are 3 organs of the state.
Yes.
Correct?
Yes, Madam.
Now, if minister is the executive, then
Well, can it be on 8th, Madam? We'll clear everything, Madam. On 8th, Madam. Next Tuesday, Madam.
not next Tuesday, it's 7th. Tuesday is the hearing day. We wanted to reserve few dates for hearing.
No, Madam. All right, Madam, 7th, Madam.
7th,
Wow.
okay. Mr. N. Evil and counsel for the petitioners submits that the order of transfer and posting of the petitioner was issued on
28th October 2024.
on
28th October. 28th October 2024.
28/10/2024. And the joining report of the petitioner was
6th
made
November.
on 6/11/2024. So, however, comma, despite the order by the competent authority, comma, the petitioner was never provided with the charge of
BDO.
In charge video.
huh?
In charge video.
Of, where is that?
Madam,
Page 20.
21, Madam. Column number 5, Madam. Serial number 1. Sri Baki Bakam. Column number 5. Parsi Parlo Block S in IC video. In charge video.
Oh, okay, as Parsi Parlo block as in charge video. Yes, sir. On a query of the court, Mr. B. Pichal, standing counsel for the
RD.
RD means
Rural
Development Department. Has submitted that as per instructions received by him, comma, due to communications made from the personal department, comma, the authorities in the Rural Development Department has not been able to take a decision on the effective posting of the petitioner. Full stop. It is also submitted that although the petitioner is being given his current salary, comma, the petitioner is presently not with any post. Next problem. Although the learned counsel for the petitioner has submitted that the respondent number 9 is allowed to work as in charge circle officer from BDO for last 11 years. We cannot take cognizance of this statement as it is not borne by. It is not within, as it's not needed. Next paragraph. Later on, comma, upon instructions, comma, the learned standing counsel for the Rural Development Department has submitted that the respondent authorities are now mooting a proposal to transfer the petitioner to another place of posting.
Yes.
And it is submitted that the consent file is now before the concerned minister of the department. Under these circumstances, comma, the learned standing counsel for the Rural Development Department pays for time till they're making it 9/4.
Right.
Days you may not be able to make some days time to have the matter listed on 9/4/2025 so that you can produce updated instructions.
Yes.
Next paragraph. When the updated instructions are produced on 9/4/2025, comma, I can just say that at this stage, we would like to record that the adjournment of the matter today shall not be construed by the authorities as if the court has given its approval to the proposed transfer of the petitioner to another place of posting. And therefore, any order of transfer that is passed shall not be enforced till further orders of the court. Next, for a list on 9/4/2025. We are not saying because the transfer policy is there, we are not saying that we are giving our promoter to the transfer.
Yes.
So don't enforce that before that date.
Right. Obliged, my lord.
I mean, service report on respect to 4. There is an office note, my lord.
Just a moment.
1/4/2025.
Mr. Purkasto, may I ask you this, today, we did a matter in the division bench. Is he the same person?
Yes, same person.
If he's a government employee, can he work in a, can he be the, what do you call, executive of a multipurpose cooperative society? Is that permissible?
Not cooperative society.
Oh, that is a teachers association.
Yes.
There is a teachers association. Okay.
Teachers.
Okay, then it's okay. Yes. Notice is not served.
Not
For respondent number 4. Who is respondent number 4?
Astronaut who is Deputy Director.
Why he is by name?
Because some allegation is made, my lord. Earlier advocate, it is a transfer brief, my lord.
There's no relief sought for against respondent number 4. We'll have to strike out his name.
Yes, my lordship, please. My lord,
Where is the pleadings of Malafide against
Possibly, my lord,
respondent number 4?
because I have been engaged newly, my lord, so.
No, but still,
entire record is also not with me. So possibly, my lord, there is some allegation made against him in personal capacity.
I forgot the year. It's a judgment authored by Justice V.D. Gyani.
Right.
As he was then. He had said that once a lawyer appears in a matter by filing Vakalatnama, he is
He must be
expected to
acquainted.
be, to be duly instructed.
Yes, yes, my lord, that's right. I'm trying to contact the client, my lord. Brief is given to me, but entire record is not with me. Even then, my lord, if you lordship desires to strike off his name, my lord.
No, please be sure. We don't see any allegation
Yes,
of
my lord, that, my
Malafide.
lord, the petition is also not with me, my lord. Unfortunately, my lord. I am trying to contact him, my lord. By that time, I will be able to collect.
Mr. A.K. Purkasar and counsel for the petition submits that notice on respondent number 4 is not yet served. So accordingly, the petition is granted 2 days time to take fresh steps for service of notice on respondent number 4 by registered post with AD. As the respondent number 4 no, so in addition, the petitioner shall also serve notice by on respondent number 4 by way of justice by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next para. On the next date of listing, the learned counsel for the petitioner shall address the court as to where is the pleadings regarding Malafide against respondent number 4. And if there is no pleading to that effect, whether the petitioner is ready and willing to have the name of the respondent was struck off. Next para. The notice is made returnable on 7/5/2025. So list accordingly.
My lord, anything, my lord, omission commission not, but I may be excused.
No, that's okay. Mr.
All right.
Mazumdar,
My lord.
there's a mention made in your matter. We asked you to stay back.
Yes.
Which is that matter?
Item
You are not
26.
Lordship, it's item 26. In fact, now, Lordship, what I'm thinking, this matter can be disposed of with simple direction. Or issue is very simple, Lordship, here. Only simple direction. The matter can be remanded back to deputy commissioner. That's all.
A lawyer, number 1, a lawyer is simple. Number 2, a writ petition is simple.
Even government. It's
I don't know.
Only if a deputy goes to be sent.
No, not that. At one point of time, I was also a simple lawyer. Mr. Mazumdar was also a simple lawyer.
With time, that simplicity has gone. Because only complicated matters come, so one cannot
but
remain simple.
That simpleness was only Six months or 1 year.
But in this case, my learned friend is correct in saying that it will be ultimately decided by the collector. What has happened is here, so many things are there, but in nutshell, the matter is like this, my lord. Land was acquired and objections were heard. Section 9 notice was also issued. And after that, my lord, when we raised objection that we are entitled to compensation, there is a committee, my lord, a committee has been formed.
We understand. You told us that they are females, so that you say that
These
full
two
compensation would not be granted.
petitioners, they did not have any brother. So 4 petitioners, they are sons of 2 brothers. Both the my persons did not have any male child. Now they say under the customary law, female is not entitled to inherit. My lord, that is in the
Maybe they don't know the story of Mrs. Indira Gandhi. You don't know the story of earlier Prime Minister Mrs. Indira Gandhi, late Mrs. Indira Gandhi. You don't know the story. She went on being a female. She went on to become a Prime Minister. Inherited the post from her father. So when one can inherit the post of minister, Prime Minister, there's a famous politician in Bihar. When he was in jail, his wife became the chief minister.
Yes, we have seen that movie.
I forget names.
In fact, Lordship, here, the DC is the only one who is the verification authority.
Just
So
one
he has to
document. One document you will, Lordship, will examine. Page 197, running page.
197.
That is the issue, madam.
In the second writ petition.
No, Lordship.
WPC
Rejoin that.
167.
In 167. Page number?
197, running page, madam.
197.
Of my affidavit, I believe.
It is their affidavit, they have annexed.
Yes.
My lord, Lordship will kindly say on top there are 4 names. Anjali Yala, Amy Yala, Reshmi Yala, Nana Yala. Lordship is Lord Mayor. These are the 4 petitioners. When they have approached the Deputy Commissioner says it is to inform you that the land acquisition proceeding of Italian hydroelectric power 309 megawatt project had been completed following all process laid down as per rules and guidelines of the Land Acquisition Act. Further, it is to bring to your notice that final award for the project was published by the District Acquisition Authority on 20th July and 16th December 2015 after completing all the process. Therefore, you are hereby advised to approach your concerned village committee for any kind of claims and objections in the PAF's list.
No, this can't be permissible.
He himself has to hear. Now, what has happened? These persons have formed a committee and they have issued a letter to the Deputy Commissioner. Kindly don't release these compensation to these persons because we have already earmarked 20% only of the entire compensation for the female members who are claimed. What has happened is a vacant land. Now, these 4 persons, they are ladies. After marriage, they have gone away. Now they are saying, although it's a community land, all will get a compensation. You will not get because your father did not have a son, female, you are married off, and you are not deciding. So my only prayer is compensation has just been deposited in the month of the last month. So far as this particular village is concerned,
What do you say, Mr. Saxena? No,
for this particular my lord village, Emuli, page 99, it is mentioned 115 area hectare.
Page number?
Page 99 of the government affidavit. Because once compensation is disbursed, it will be difficult to recover my lord from those who have got in excess.
Page 99. Yes.
This is the award.
I'm not being able to follow you. What is this page 99?
My lord, award to put some. My lord, page 99 is before the award when they have prepared a list, my lord.
Okay.
In the list, your lordship will find serial number 9. Dibang Valley.
Serial number 9.
Yes, serial number 9. Dibang Valley, project Tehsil Circle, Italian, and localities Emuli. Different villages are there. We are concerned with Emuli. Now, the compensation for the village Emuli, once it is disbursed, for others, I am not requesting sound court to stop payment. For this Emuli village, where we are there, admittedly, my lord, their only ground is that we are female, we should not be granted.
Yes, Mr. Saxena, what do you want to
Yes,
say?
Lordship. My contention is that Lordship, kindly come to page number 43 of the writ petition. Page 43. It is the representation before the deputy commissioner. It is still pending before the deputy commissioner. So that may be disposed of first. And Lordship, page number 203 of my affidavit in opposition. Here, Lordship, in a similar situation where my learned senior was himself was there in the case. Page number 203. Relevant page, Lordship. Page number 206.
Page
There-
40, page,
206.
no, page, what page you wanted to show us?
Page 42 of the writ petition.
42.
43. Annex 5. This is the representation before the deputy commissioner, which is yet to be
43 appears to be incomplete.
43 of the writ petition.
43 of the WPC 167
Yes, Lordship.
appears to be incomplete.
Yes, it's their document, Lordship.
We don't know, Mr. Mazumdar.
My lord, lordship may not go into all these things. My lordship may kindly turn to page 199. What is the
No, but
problem?
it's okay, but page 43, he says is the representation. Appears to be
43.
incomplete.
43. Just, so 43 too.
Even if in a very similar situation case, Lordship, the coordinated bench of this very high court.
You see, question of disposal of representation will never come.
No.
Because he's the acquiring authority, he will have to decide.
That's true.
What will he do with disposal of representation? No,
That's true, Lordship.
he must exercise original jurisdiction.
Yes.
My lord, the deputy commissioner, I have shown my lord, deputy commissioner has asked me to approach the committee. There is a reason, my lordship may kindly see page 198. Just two documents I'll show that will be there.
119.
198.
190.
My lord, oh, yes,
198.
part of their affidavit. 198, my lord. 198, my lord.
Yes.
This is the letter of this office of the Emuli Community Land Preservation Society. What should we have seen, my lord?
Yes.
A society has been formed. Now this society serial number 6 and 7, what will you kindly see? 6 and 7 below. If any sum of amount is paid by the project proponent as compensation for the community land, the amount shall be deposited in the so-and-so account and shall be operated, distributed by the selected members from within the village committee. All sisters, widows particularly, my lord, enlisted by the community will be given 20% of the total compensation amount and shall be equally divided among them. They will have not right to claim any rights since the fixed amount is being given to them as token love by the committee, my lord. Then page 202, my lord. 202.
Yes.
Based on this resolution, they have taken at page 198, they have written to the deputy commissioner this letter. Reply against complaint forwarded by these writ petitioners. And then the third paragraph, Lord will kindly say, however, it is disheartening to learn that some of our
Which page?
page 202, madam.
202.
Madam.
Yes.
Based on the resolution as page 198, which I have read just now, this committee has written to the deputy commissioner and just Lord may kindly see the third paragraph starting with the word however. Lord has got manner. However, it is disheartening to learn that some of our own sisters have written before your kind self for the inclusion in the list of project affected families in village level community, stating that they do not have their father or brothers, whereas it is pertinent to inform your good self that in affidavit bearing number so and so, we have clearly reserved, they have reserved, not the deputy commissioner, 20% of the total compensation amount for the female community members, which includes sisters and widows of all community, and there is no any scope for claiming rights against the deceased person for whatsoever reason as per the adoption of the resolution, etc. Now, the last but one paragraph. Therefore, we, the undersigned, would like to pray before your kind self not to entertain such irresponsible and fake claims. This is how the Deputy Commissioner is now writing in response to our letter.
Who's appearing for this society?
My learned friend is appearing for the society. They want that they will distribute the compensation, not the collector. I need not say what is the power of the collector before this court.
There is my lordship.
It is the collector who will decide claims and objections. They are
Mr.
restricted.
Saxena, nothing simple about this.
No, lordship, whatever, in the first I've said that let the matter be sent to Deputy Commissioner, let him pass a speaking order about this representation, all about this facade. Then disbursement can be done.
No. See, the Deputy Commissioner has sent it back. He says that the society will take the decision.
Yes.
No, as per the
Society has
page number
already taken a
43,
decision.
it is yet to be disposed of, page number 43.
Society has already taken a decision.
Lordship, society is different and Deputy Commissioner is different. Deputy Commissioner has not given anything as of today. So let Deputy
But
Commissioner,
now you see,
first of all, Deputy Commissioner has to be.
in Hindi we have a word. It's called Janta Janardhan. See, if the common people write, don't take action. Deputy Commissioner has said that, okay, I will not take action. You decide.
That is well, Lordship. Simple direction from this court to the Deputy Commissioner to dispose of their representation and to pass in speaking order. Because the award is of 2015, Lordship, and we are in 2025 now.
It is not permissible for the court to do that. The act says that the Deputy Commissioner is being the land acquisition officer.
Then my friend will answer this because
he will have to take a decision. He can't dispose of a representation. He will have to take the alternate decision. Disbursement has to be made by the Deputy Commissioner. The funds transferred has to be taken back. He will decide the quantum.
in a similarly situated position, Lordship, this coordinated bench has in page number 206. 206. 203 is the first page. 206 is the operating page, where my land senior was there as counsel. 206, paragraph 9. The prayers made by Mr. Majumdar Land Senior Counsel is declined for a reason that it may not be in the larger public interest to stop the disbursement of compensation for which large section of the benefits.
No. You see, very difficult when you say similar. When you say similar, I read
because they are not physical position.
When you tell me similar, I start reading from page 203. I read the first line of page 203. The Guwahati High Court of Assam, Nagaland, Mizoram, Arunachal Pradesh, Itanagar, case number so and so. Number 1, Ringte Mihu. Next line, son of late so and so. So if this is son and that is daughter.
Here, one thing also has to be seen that whether they are in a physical position, because they are not belong from their village. They have already left the village long back.
Where is the documented customary practice?
Not documented.
That after marriage, one ceases to be the owner of the property?
Yes.
Where is that?
That is not codified as of today. It is under process for codification.
My lord, there can be no law of inheritance where after the death of female, the inheritance will stop if there is no male.
I don't know. There may be way asking that.
Where the property will go? I'm just asking myself, my lord.
It is a custom.
Where the property will go then?
Practice since time.
Suppose there is no female member, it has to be that in the absence of a
Deputy Commissioner has to give some speaking.
I don't know about the communities, but there's a young girl sitting, a lawyer sitting behind. Can you come forward, madam?
Madam, she is also there. She will be in a better position.
No, she is senior. I want to hear the
please come forward.
Junior most.
Please assist the court. Come forward.
Yes, number 1, a piece of advice. under the Advocates Act, when you appear before the court, you must be fully attired. Correct?
Yes.
Sitting there is also appearance before the court. Correct? Next time, never do it. Second is that this court is not a drawing room or a changing room where you can wear clothes and come. So the wearing of gown within the court room is again very bad practice. Number 3, the main point. I don't know about your community, but it is acceptable to you as a woman that after the male progeny dies, the daughters will not have right to inheritance. Is it acceptable to you? Your personal opinion. I'm not saying about your community opinion. I'm not even asking what your community you belong to. As a woman, do you accept?
Have you understood?
Do you accept that after the male progeny dies, females would not get inheritance? No, that's all. That's all.
There will be chaos in the society, my read. This is the law.
Yeah. As Lordship has observed and my senior friend also submitted Lordship. Here Lordship, the including whether they are entitled to be included in the Lordship as a beneficiary or not. The decision has to be taken by the
No, that decision is a misconception. Number 1, this is a community right. Correct?
No.
It's a community land.
Community.
Now, unless a person is said to be not a person of community, then only the question of decision will come. If the semblance of right of inheritance is there on the petitioner, what is the question to be decided? A title cannot be decided by the deputy commissioner. So whether she is a entitlement or not is something which only a civil court can decide. And number 2, what happens to section 50 of the Evidence Act? You have seen section 50. Give the Evidence Act.
Relationship.
Relationship, when relevant. So you see, the relationship of a person with a father is something which is known. Nobody says that even this respondent society, they are even not saying, they are not denying that she is not the daughter. They say that we limit the share of the females to 20%. Now, who are they to decide civil rights? And under what circumstances can the deputy commissioner, being the land acquisition officer, abdicate his right, his duty to this society to take a decision? We know about civil court that can decide rights. But we can't know of deputy commissioner sitting over the family rights of a descendant. The deputy commissioner can't say that, well, A is the daughter of B, but being a daughter of B, she is entitled to 20%. They're deciding civil rights. Can we permit that to be abdicated?
What's the inclusion part? Inclusion as a lordship beneficiary. That part has to be, the decision has to be taken by the deputy commissioner only.
No, if it is inclusion.
So for the civil.
No. The deputy commissioner must have done some exercise to find out who are the beneficiaries. These people say that they are entitled to a share and 20%. In the letter which Mr. Mazumdar read, they don't say that the petitioners are not entitled to any share, and we are giving out of are
Love and eviction.
not love and eviction, but it's a gratis we are giving.
Yes.
You can't add beneficiary by way of gratis. Benevolence.
Sorry to interrupt, in that case, my first prayer as I made this morning, since I was taken by surprise for listening today, a Lion City Council will appear on 8 coming Tuesday. Because that was the arrangement in the morning.
But no disbursement.
No, it's okay, Lordship. As my learned
In
friend said,
respect of the-
because disbursement will, at least it will take 1 month more.
In respect of the share relating to the petitioner.
Till date, there will be no disbursement.
On the prayer made by Mr. K. Saxena and council for the responding number
4 to 8.
4 to 8. No, this is it. Mr. K. Saxena and council for the petition case for adjournment. Mr. D. Muzumdar and senior counsel assisted by Mr. P. Barwa, counsel for the petitioner. Has submitted that the respondent number
4 to 8.
4 to 8. They are 4 to 8.
We have implemented ourselves.
page WBC 167.
Yes.
Madam.
I don't know. We are only. Where is this society?
Society is not,
Society
is not a
does not
party.
come-
I am not a society. I
Madam-
am the land. I am also beneficiary.
No. Members have come and they are saying, my lord, will kindly see it. I will show from their affidavit. They are saying that they are page 148. The first, third page, paragraph 4. Respondent number 4, 5, 6, 7, and 8 have implemented themselves in the instant writ petition in the representative capacity of the villagers of MUE village under so and so, more particularly for the society, MUE Community Land Preservation Society. So the society in the through their members have
By
come,
names.
implemented themselves.
You should not have permitted that
My lord,
implement.
at that stage,
You should not have done it
cannot be yes.
because
I've seen-
if they have joined as representative capacity, in the morning we took up the matter.
Yes.
Order 8 to 1, order 1 to 8. Notice has to be issued. You must be empowered by the society. The court will not be knowing that you are empowered by the society to do it.
And Lordship, the society is not registered at all. They are not registered.
But then they are giving representations. And therefore, everyone who is the part of the society must be given notice. We have to, we have told you, we have been able to locate that Karnataka decision. Karnataka says order 8 to 1 does not, order 1 to 8 does not apply in a writ petition. But once you impede yourself and claim that you are for the society and the society is not registered, then you will have to give a newspaper advertisement now. You have to be burdened with some more cost. That is the requirement of order 8 to 1, that you should give a notice to all concerned. Otherwise, your appearance as a representative capacity cannot be accepted.
But while implementing ourselves in the IA, we have just simply said that we are also the beneficiaries. We are the affected parties.
You see, then Mr. Mazumdar, your case will be dismissed for non-general necessary party.
Yes.
If somebody is giving a representation and you're not there.
My lord, in our case, our prayer is very simple. We don't want to affect anybody. We do not want to say that from their share we should be given. We are simply saying that our share should be given to us and our grievances against the deputy commissioner.
But in the pleadings now it has come that some society is objecting.
Society, my lord, society particularly has no right to object.
But even that.
That is why.
You see, it is your case that the society had given an objection. Thereafter, the deputy commissioner has.
Your lordship is correct factually, but then our grievances against the deputy commissioner has delegated his power to the society, which the deputy commissioner cannot. Under section 9, it is the collector who has to decide.
You have to impede. There is no way out. Once you show us the documents, and then you present your case that it's been abdicated to that. And you are saying that you have been asked to go to that
committee
by
the deputy commissioner.
That committee. Then your rights are immediately affected by that. They have to be made a party.
If necessary, we'll make the society also a part.
You have to do it. There is no other alternative. Even if it is unregistered, you'll have to make it a party. Because it is their resolution to restrict your rights to 20%.
Compensation, yes.
Explain the Mr. Dismissal and Senior Counsel for the assisted by Mr. P. Sharma and Counsel for the petitioner submitted that that he has been instructed that some days back the land acquisition compensation has been provided by the Deputy Commissioner Anini
on 26th of March 2025.
Which district? It is
Dibang Valley.
The Dibang Valley district. Anini 2. Yes, 2.
The compensation has been deposited before the deputy commissioner by that authority method.
Which authority?
NGK.
Italian respondent number 3.
So it has been deposited by the acquiring authority.
SGVN requiring authorities.
Okay, we are not saying that.
Vidyut Nigam Limited.
That is respondent number?
He is not a respondent.
It's not respondent.
Huh?
Not indeed.
By the acquiring authority to the
Deputy Commissioner.
To the account of the Deputy Commissioner, Dibang Valley District.
On 26th of March 25.
Dibang Valley District, Anini on 26/3/2020.
Yes.
5.
Fine.
So it is submitted that from the materials available on record, there is serious objection by a society to the disbursement of land acquisition compensation to the petitioners as they are female members of the family, the share of the deceased father. So, accordingly, Kamai is submitted that the said part, the share of the petitioners, the compensation may not be released to any third party. Accordingly, the learned counsel, the senior counsel for the petition also submits that he be granted liberty to file an appropriate application for including of the said registered society as one of the respondents. At whose instance, the right of the petitioners to compensation is sought to be curtailed. Next. Liberty is paid for is granted. Next column. We also heard Mr. Estapin, the senior government advocate on the in connection with the prayers to made. Next, it may be submitted that that Mr. K. Saxena and counsel for the respondent numbers 4 to 8 has submitted that the issue can be sorted out by directing the
Deputy
Deputy Commissioner, Divan Valley District, Anini to decide the representation submitted by the petitioner on 2023.
Amar. 45. Page 40.
Huh?
Page 40.
43. Just give it the date.
25,
10, 2020, 23. 3.
Yes.
Next para. Be that as it may. The court is inclined to grant liberty to the petitioner to file an introductory application for including of such parties as the petitions may be so advised. Next para. In respect of the representation dated filed by the petitioners before the Deputy Commissioner, Divan Valley District, and is concerned, the pendency of this writ petition shall not be a bar for this authority to dispose of the representation of the petitioner. Mr. Bhava. Insofar as the share of the petitioners to its compensation is concerned, the same shall not be disbursed to any third party. Stop. The learned senior government advocate shall, if any orders passed on the representation submitted by the petitioners, the Deputy Commissioner, Divan Valley District, any shall transmit a copy of the order to the learned senior government advocate for being placed before this court. Next para. The petitioner said produce a certified copy of this order before the district Deputy Commissioner, Divan Valley District, so as to facilitate him to take a decision on the representation submitted by the petitioners. Next para. We hope and trust that the representation of the petition shall be disposed of by the said authority within a period of 30 days from the date of this order. Next para. This is the matter on. We give 30 days time would be this second.
Lordship may give us 2 weeks time because he will have to file application for impleadment, then again notice has to go through that.
No, that's separate.
Right.
But the representation, because we are giving a
Yes,
date
yes.
so that the representation we know about that.
Yes.
This one 7th May. This
10 days.
Pardon me.
10 days may be given.
No, we are giving you 1 month
10 days is sufficient.
for decision.
Disposing of the representation.
10 days will be sufficient. Okay.
Because there's 10 years have passed now. 10 years have passed after the award.
No, we were giving 30 days. You want 10 days.
I want 10 days.
Okay. 10 days would be from here to 12, vacation would come. This one 23. We didn't say we hope and trust. You say that the government, senior government advocate submits that 10 days time would be sufficient for the said authority to dispose of the representation. Accordingly, in view of the ensuing view vacations, list the matter on 23/4/2025. So the London senior government advocate shall produce the order of if any passed by the said by the Deputy Commissioner Dimangwari district of Manini on the representation submitted by the petitioners. Okay. We will not take up any of matters. It's already 6. Nearly 6. Other matters will be rolled over. Yes, if there's any interim order, please tell the court master that the interim orders will be extended.
Lordship may rise.
Pardon me?
Lordship may rise. No, if there's no.
No,
such request.
I'm asking if there's any interim
No,
order.
there
to be
is no-
extended.
there is no request.
No, okay. Okay. So, Mr. Saxena, nothing very simple. How much time you have taken with this simple?
I have not taken much time, Lordship.
He has made the court to take time.
Huh?
He has made the court to take time.
So many things may arise. This
That is.
order 1 rule 8 and all, everything comes. So.